I'm going to constantly refer to things that I have personal connection to. Someone might say, well, I didn't come here to hear personal stories. I don't really care. I'm going to tell them anyway. It's my way of communicating. You're only stuck with me for a few hours. I do care. I don't want to sound like a smart aleck, but it's my way of communicating in a more meaningful way. You know, they always say, and I think I'm a better lawyer because I had a different career before I went to law school. I was a teacher. And when you teach, there are what you call educable moments when you're connecting with somebody and you know they're following you. Okay, and any of you who've done trial work know that that's important. When you see a juror looking at you and they're leaning towards you and you're listening, you need to make sure you keep that connection as much as you can. So when you have like little stories that go with it, it makes it retainable, for lack of a better word. Retention it's one thing to communicate, it's another thing to have the person remember it. Case in point, law school. Seems like law study would be anything but retainable because of the sheer volume. And I stand before you as a person who I've never thought I was as smart as anybody in my class. I never thought I was as smart as anybody in a room that I'm teaching in class. In law school, I was always fearful that I wasn't as good as the people next to me. You know that old story in the movies and whatnot where some law professor says, take a look to your right, take a look to your left, down below and above, you know, those choir rooms. It's my job to get rid of every one of those before you graduate. So, wow, that's a great way to motivate a class, but that's scaring people, you know. Was that guy's name Hauser or something, that TV show? Yeah. What's his first name?
John Housen.
Yeah, Hausen, not Hauser, right, Hausen, great. So, having said that, I said, oh my goodness, I'm 32 years old. That's when I started law school. I'm an assistant principal in a high school. I'm a football coach. What the heck am I doing here? If there's one to your right, one to your left, up and down, I gotta be one of those four. I mean, that's what I kept on saying to myself. So this is what I used to do, and I'm not embellishing. I used to hand write every brief for every class. I never did canned briefs. I always wrote out my brief, you know, the facts, the holding, the rationale that supports the law and all that stuff. And what happened after that is I started hearing the classmates whispering about Gilbert's and Emmanuel. Did they still have those things? These outlines or whatever they call them? Anyway, so there was a whole bunch of people who said, absolutely, anybody are worth, you'll never get through this place unless you have Gilbert's. And of course, somebody was just as passionate about Emmanuel. Emmanuel was called, and I don't know if they're still out there. But so, insecure me, I bought them both, okay? And what I used to do is I used to go home and I would look at the canned briefs and look at my briefs and see if I was wrong. And of course, if the canned briefs disagreed with my hand briefs, it had to be right. I couldn't be right? So I started connecting the hand briefs to the canned briefs and then putting them in the outline. I am telling you, I did this, I am not kidding, every night after class. And I live in Newcastle. It took me 5 hours to get here. I left last night at 9:30. Yes, I got here about 2 o'clock. And so in Pittsburgh is like about, back then, no 279, right, Dante? And so that took us about an hour and 10 minutes to get through downtown Pittsburgh to get up on the bluff to Duquesne. Anybody ever go to Duquesne University in here? Great, so you know where the bluff's at, up on the hill. And Dean Shula?
Right before him.
Okay, before
I know Dean Shula very well. He's a great man.
Oh, yeah. And you're a Dean Shula person?
No, I only went to visit the campus.
Okay.
To visit some friends, so.
Okay. Anyway, so up on the bluff, and I had to drive down there. So then I would get in my car and head back home. And I had to get up at something like 3 o'clock every morning to study, to read, because I wasn't to this day I read slowly. I'm not a fast reader. So I had to get up, so that when I had been to the high school, I was an assistant principal at the time. I had to get to the high school by 7:30 a.m. when the buses started to arrive. They used to call me Buford Pusser in our high school. And again, I'm dating myself, I'm sure, but Buford Pusser was from a movie called Walking Tall down south, where he hit people with a stick. He was a sheriff. He was big, everybody was afraid of him. But I used to stand on that sidewalk, and those kids would go past me, and it was the beginning of keeping my building running properly. And, but I had to be there first. So I did that, and I would head home, and that's what I did over and over and over again. But something weird happened. I actually retained that. And I know a long way from where we started, okay? But I retained that. To this day, no, I'm talking like, that's back I graduated in 86. To this day, I can hear a fact pattern. I can sit through an interview with a client, and I know where this belongs. Isn't the table of contents, isn't the cases, isn't it kind of like a Christmas tree, for a timely metaphor, okay, analogy? All of it is like a Christmas tree, and all of these things are the ornaments that we hang on them. They kind of fit generally in a certain area. When I took essay exams for law school, the first thing I would do is frantically flip the book over, and I had memorized the table of contents, and I would write that on the back of the book. And then I would read this question and try to, oh, that's right, that's what this is about. It's that part of the Christmas tree, you know. So it helps us, you know, to remember things. So I'm sorry if I'm going to give you a little bit too much of that, but it's just how I teach. So in the world of practicing law, going back to my own, I was coaching football once upon a time, and I bought a trophy for my football team. It cost $80-some, and I watched some young lady make it in about 10 minutes, and I went, wow, that's pretty cool. So, and the guy ended up passing away. I bought the business, and we were successful at that. And I'll never forget, it was my first time out in business, my first time as an entrepreneur. This is really cool. Back then, when you're brand new, no one ever taught you anything about business. It's really neat to see all that money in a cash register, but not very neat if you don't remember that the government gets so much. You have to pay employees, you have to do this, and it looks like you're really killing it, but yet you don't know about the gross versus net. And soon I picked up on that, and I said, you know what? This would be so much fun if I didn't have to buy the marble. Back then we used to have marble for the bases of the trophies, and the whole thing was not the marble, it was the weight, the shipping weight, to get it from Italy to America, and from Akron, where we used to get it. So I tried to snip that off by driving to Akron with a pickup truck sometimes to get a load of marble so I always sat there and I said, wouldn't it be really neat if I didn't have to buy anything to resell? Well, think about it. That's what you have right now. Each one of you have a business in your head in which you can sell something that you don't need to pay for again. You already did it. So it makes no sense to me when I'm in a room full of people that so many people aren't practicing law, you know. But that's a personal choice I made, and maybe certainly not a personal choice. But I would think that one of the things that you might be concerned about is that, well, that's kind of scary. So we're going to try to go down through some of the unscariness of it. And I've been doing it maybe by accident. I didn't have anybody who was knocking down my door to give me some big law firm job in downtown Pittsburgh. I did well in law school, but I didn't have all that law review stuff and everything. I decided I wanted a life, too. I wanted to be able to go home. I wasn't, you know, sometimes we get so caught up in it, you do need time to get away from it. So I started practicing law, and I can tell you this, what I'm about to share with you, I learned probably by making mistakes more than by doing anything correctly. But I am proud of what I have and what we have. We have an old mansion. I passed out my business card there. I think it's on the pictures of it's on the back. Yeah, an aerial view. We have an old mansion, 20th century mansion. The guy who, in Newcastle once upon a time, 40, 50,000 people, Dante? And it was thought to be a very powerful city, and it was back in the 20s. Largest silk mill, largest tin mill, all these things. The building that I now occupy as an office was the home for a guy named George Johnson, who invented molted bronze. Johnson Bronze was the company. And so it's really kind of neat. It's like living in a painting. Our building has probably stained glass in it that's worth more than the city by now. I'm convinced 1902 the building was built that Tiffany probably created a lot of that glass, but I'm not about to disturb the frame under it to try to find the Tiffany. Although every once in a while when it gets really lean financially, like in December, if you're in private practice, you probably see a drop in your revenue because people don't have disposable income that they're going to spend suing somebody else. They're going to spend it somewhere else. So every once in a while when it gets lean, you look at that one big, huge stained glass window. You know which one it is. I feel like I'm looking at a golden goose or something, like whatever. But the light fixtures have electricity and gas. Some of you have older buildings around here, I'm sure. Both, because they weren't sure that electric power would catch on. So the light fixtures are still a combination of gas and electric. Although there's no gas in the building anymore. We did cut that off. So choosing to be in practice is kind of like the first in the beginning. Now, that could be a problem if you're like me and you live in a city like Newcastle, because people come to you rather than what you know, what special area you have, than who you know. They know of you, they've heard of you. And you have to have, you got to be ready to 1 minute be in criminal court, the next minute be in divorce court, the next minute be in, be writing a will, enforcing a will. We're doing a lot lately. We're seeing a real spike, and I guess it's because of the age of the population in Pennsylvania, on people who are fighting over wills. I mean, it was rare we used to get those cases, but now it seems like every week somebody new comes in the door fighting their siblings over she didn't probate the will properly, or somebody's stealing my money or something, you know. So in our practice management, the book that you have that was given to you, one of the things we have found, and this is one of those little catchy phrases on what we were trying to give Ben a little nugget for him to get some interest in the course. If you need a protection from abuse order or a collection attorney for your office, we have an easy practice management plan that really works, okay? There are times when you think you might need a protection order from your own client, and certainly a collection attorney. Collecting, especially if you're by yourself, is always a hard thing. It's also a hard thing for you to talk about. I mean, think about it. The attorney-client relationship is something that is so fragile anyway. And then after you're done, you just say, okay, I'm sorry, your time is up. By the way, did you pay your bill? How do you maintain that attorney-client relationship in light of that? Well, you not only can, you have to, because your secretaries are probably not going to collect you. You're here for a CAPE Institute class, huh? I did it again, see? Sorry. Just sign in right there somewhere. And here's a card for you. Now, to give you some tree to all these ornaments we have in boxes that sound like they're fragments all over the place, I'm going to kind of like give you an overview of the idea that, number one, we want to keep attorney-client relations as sound as they can be. Now, I want to give you a caveat, too. We know that people are mean sometimes, and people are mean to their attorneys. Have anyone ever experienced a mean person since they've been alive? Yes, of course. Well, they seem to really get mean when they get into their attorney's office. I saw that when I coached football years ago. That's why I quit coaching football. Some of the people said anybody could have won with that team. Wasn't me at all when we were successful. And somebody else would say that, God, that team should have been a state champion. It was that idiot that was the coach. So I see that again as an attorney. Anyone could win with that case. I was right, for crying out loud. I'm glad you got the judge to listen to you. I'm glad that you followed my advice and said what I told you to say. So anyone could have won that. And if you don't win it, it's because of you that it didn't turn out with them. I love giving this to my divorce clients. Who married him? I didn't. You did. Okay? I inherited that. So every once in a while, anyway. So that tension between the client, the result, and everything, and then of course being paid. Okay. So the rules that we'll talk about. Again, I'm going to give you a nice little Christmas tree here. If you take a look at these rules, it's very, very important to know that the 5 or 6 rules literally are the backbone of running a practice. And maybe some of you who aren't practicing law are kind of afraid of that. So we're going to go over them anyway. So rule 1.1 is your competence rule. And without going into discussion yet, a lawyer shall provide competent representation to the client. Competent representation requires the legal knowledge, skill, thoroughness, and preparation reasonably necessary for the representation. That's the ethical requirement that we have on Rule 1.1. The next rule that is very important is Rule 1.5, fees. Okay, you're in business. You can't help anybody if you can't pay your secretary, and you don't have a secretary. You can't help anyone if somebody doesn't pay and you don't have the latest in software or research. There is a sustainability hurdle that has to be overcome. And one of the things I like to say that it's important for us to remember that it's fairness too. How unfair would it be if one client unquestionably follows everything you're saying and every Friday comes and pays or pays a retainer up front and they're carrying 7 people who don't pay at all? How fair would that be? Not is the answer. Okay? So you do have to be fair. And I think that it all starts going back to that attorney-client relationship. Everyone in this room probably has been in a store like Walmart and run a bunch of stuff through the scanner. Not for a minute would you get to the lady with the blue vest and say, "Can I talk to Wally? I was going to ask him if I really have to pay what that says, or can I pay it later, or can I stretch it out on payment?" See, one of the problems with the billing is that connection of the attorney becomes the collector too. So hopefully we'll be able to show you how you can actually turn billing into a process where you step back from it. I've had clients say, by the way, this was blah, blah, blah. And I go, "Listen, I don't do anything with billing. Check with the girls. They'll talk to you, So you can't do that unless you have some kind of a process. Anyway, 1.5, we will talk a lot about 1.5 and some of its problems. Also, in the book is 1.3, the diligence rule. And the comment in that rule says, "Perhaps no professional shortcoming is more widely resented than procrastination." Okay? Wow. That actually is something that maybe why a lot of people don't practice law. I tell our young lawyers that if you have no work at all, you get out of bed on Monday morning and be at the office at 9 at least, and don't go home until 5. I don't care if you have nothing to do. Spray the glass on your desk with Windex and keep wiping it. The worst thing you can do is say, "I don't have anything to do, so I didn't go in that day. I didn't put a tie on that day," or "I didn't put a suit on that day." It's really weird. I have seen that when you show up and you're ready to go, it seems like work comes in. It really does. But it's very important. Self-discipline is very important. And all of you learned that in law school, or you wouldn't be sitting here right now. And even the non-lawyers that are sitting here know what that means. The most important thing to overcome is that desire to do nothing. Okay? And way down deep, and I don't want to sound like some psychologist here, but the more you lay around, the more you want to lay around. The less you lay around, the less you want to lay around. It just seems to work that way. So you have to force yourself. I remember I hated Mondays. This is a Monday. Today's a Monday. I hate Mondays. I'm actually having fun this Monday because I'm talking in front of people. Maybe that's different. My wife says I keep an inflatable podium in the trunk of my car, by the way. in case anybody wants to hear a speech, I'll blow it up and start speeching at anybody at any time. Anyway, so, by the way, she's the kind of a person who brightens up a whole room when she walks out of it, you know. It's the truth. I mean, she hates everything. We might want to edit this part.
They're awake anyway.
So I can wake them up. Right. Okay. But anyway, where were we? So it's that. So I started taking off on Mondays. Guess what? I started hating Tuesdays. And so I started thinking about half a day on Tuesday. I'll go in later. I started hating the first half of Tuesday. You know what it is? You got to show up, get started. Something happens, and something gets you going. Okay? It is amazing to me, and when we get to our second class, a lot of you are stuck with me again. It is amazing to me how there are things that you don't know. There are things that are going to happen today in my life and yours that none of us anticipate that are going to make it kind of cool. It won't be something that your trumpets from the sky or something, but there are moments that happen throughout the day that kind of like make you feel good. Somebody smiles at you or says hello or something. You really can key into what you're doing and starts to feed you and fuel you a little bit. So anyway, you have to show up. And diligence is important. Procrastination is a real enemy to an attorney. Real huge enemy to an attorney. I tell my son, who by the way is my partner. He's 38. Wow, he's my partner. My son has the opposite of procrastination. He just works on a file forever. He doesn't understand that at some point in time you have to choose what the area of the law is and what procedural is and draw it to a close. You can't just write up everything, because I think law school teaches us that. And so I tell my son that deadlines are your friend, because deadlines actually make you produce. So it's shocking to me how many people, including myself sometimes, have 2 weeks to do something, but you'll do it 2 hours before it's due. You can't start before that time. So I always like to give this scenario. If you read the comments in this rule after that word procrastination, a client's interest often can be adversely affected by the passage of time or change of conditions. In extreme instances, as when a lawyer overlooks, by the way, I'm on page 29, I know you don't have your book, but someday, lawyer overlooks a statute of limitations, okay? That's not a good thing, especially we're in a state here where you can file a writ of summons wherever you want, right? Precipice for writ of summons, everybody know what that is? Okay, well, not every state has it. In fact, I think we're now the rare exception. But when you have a set of facts come in and you file a precipice for a writ of summons, then you toll the statute of limitations. You might not know enough about the case to file a complaint, but you preserve the statute of limitations as best you can. Heads up, make sure you give your little letter between your client that, by the way, you've known about this for 10 years and you came to me today. Let's make sure we get a read on that, right? And I'm going to file a precipice for a writ of summons and whatnot. I'm going to do the best I can, but I don't want you suing my malpractice carrier to get what you never got off of somebody else, okay? I got one of those things in my office, like right now I'm having a meeting. I sent a certified letter to a client. I want him and his whole family in my conference room, and I want to hear them say, again, in unison, that you didn't cause this problem. We came to you with this problem. Because the longer you represent somebody on and on and on, it starts to drift you. But caveat to a caveat. Precipice for writ of summons, rule to file a complaint, right? Anybody know what that means? If you file a precipice for a writ of summons, you're saying, oh, yeah, that stopped the statute of limitations. Be prepared, because then the person who is the defendant can file a rule on you to make you, without even going to court, the prothonotary can make you file a complaint, a detailed complaint within 20 days. So you want to make sure that in terms of getting paid, that you got paid to do the writ of summons, and maybe enough to make sure if they rule you to file a complaint, you're going to be doing a lot of work to file a complaint, because of course we know when we file the complaint, civil attorneys, we know that that's going to create a whole bunch of things called preliminary objections. Preliminary objections cause you to amend the complaint, cause you to write a brief, cause you to make argument. Partial amendment of the complaint, it has a life of its own from then on. Okay? Anyway, all of that under 1.3. Little scenario, divorce work. This is a true story. I'm embellishing a little bit. Client, I'm doing the divorce. I think I got paid $500 or something like that. And the lady said she wanted to hire me for a divorce, and this was back in early days of my career. I said, yeah, okay, give me $500 to get started. We'll see what happens. Give me $500 to get started. We'll see what happens. That's a bizarre. Don't ever do that kind of stuff. So about 2 days later, I get this frantic phone call, and I was at a picnic, actually. It was a family picnic in our... I just saw Harry. Harry was the husband, yeah. I just saw Harry drive through town with a blonde sitting in the convertible and had the checkbooks from the business in the back seat and both of the kids. I don't know where they're going, but I know he took the passports. Okay, wow. That $500, by the way, and by the way, in our comments in the professional diligence rules, it says inconvenience is not an excuse, okay? So I had literally to leave that picnic. The next day was Monday, the hate day, and I had to be in my office drafting what? A restraining order to prevent dissipation of a marital asset. I had to file a custody complaint to make sure those kids weren't going across international borders and jurisdiction was fixed in the case. And I didn't have any time to talk to her about you only paid $500 or something like that. I mean, just all at once. And again, if I had not done that and it turned out bad, I literally not only would be sued for what I lost, I would also maybe be disciplined and maybe lose my license to practice law. So maybe that's why there's only 3 people here that raised their hand on why you don't practice law and whatnot. Okay, so those things don't happen very often, but you need to be aware that they could happen. So that's your diligence rule, and we're not going into all of that yet. And then our next rule that's important, and they all kind of ricochet off of each other, is the, on page 36, scope of representation. Now that is a friend of yours. Scope of representation. Very cuddly, little, neat friend. Scope of representation, I think most people who are frantic in their own practice of law or work for somebody who's frantic and trying to make you frantic and make sure that you got all the pressure that they're taking and whatnot, a lot of it could be solved in 1.2. Scope of representation, 1.2. You don't know if you want me yet. I didn't tell you how much I cost. I don't know if I want you yet. We're not attorney-client. We're doing a flyby at 40,000 feet. And if we become attorney-client, we'll land the helicopter, the jet airplane, and we'll walk among the trees. For right now, I need the salient facts in this case. So it would help us both if you let me control the interview and I'll ask you questions. This happened Friday in my office. This girl is so smart. She was beautiful. She was like a Miss Universe or something, contestant or something. Very attractive girl, very bright girl. She was an RN, but she was into this case, man, and she just wanted to, she got to say it all, you know. It's like one of those things like when you pull the string and you talk, only she kept pulling the string. Like it was bam, 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 bam. And I'm sitting there going, whoa, stop. I said, and then finally I started doing something that she understood. When she would do that, I would just stare at her. And I said, I want you to imagine there's this little thing on my forehead. You just hit the keyboard so many times I'm freezing now. You have to reboot me. I can't possibly think that fast. But they're so into it, and they're so frantic that you have to be sensitive to that. But you can't let them control the thing, right? When you walk onto a jet airplane, okay? When you walk onto a jet airplane, you go down the tunnel. Of course, I was just at an airport the other day. It didn't have a tunnel. I guess it was a small airport, small plane. Anyway, generally, you go down the tunnel and you go to the right. And there's all these seats and there's ladies and guy stewardesses now handing you drinks and peanuts and all that stuff. And first class, they got those thrones and everybody else is in the back. But if you go to the left, if you look to the left, you're going to see 1 million dials and levers and all kind of stuff. Nobody in their right mind is going to go left. You're going to go right, and you're going to sit down, get a drink, look at some of the weird, I love junk stuff. I'm a gadget man. I love reading the airplane magazines. And you're in there, and somebody else pulls the lever, gets it off the ground, lands the airplane. You don't do any of that stuff. So you got to tell your client, I want you to go to the right and sit down and relax, because I don't think you're competent to fly this complicated airplane, your case. And just in case you think you are, I don't want to ride with you. I'm not flying there. I think you'll crash if you try to do it. I guess you have a right to crash, but I'm not going to ride that same airplane. So anyway, 1.4 is a rule that used to be, and that's on page 42. Rule 1.4 used to be a paragraph or two, about, I don't know, 7 or 8, maybe 9, 10. I'm losing track of time now. Several years ago, it made a huge transformation. It's the rule, and maybe this is another reason why only a few hands go up. It's the rule that requires what? Malpractice, right? Anybody here doubt that malpractice insurance is required? I'm always looking for pushback every once in a while to make sure you're still out there and not asleep. Does anybody in here not know whether malpractice insurance is required? Okay, nobody wants to put their hand up at all. Okay, but generally malpractice insurance is not required, but you need to send a letter to your client and whatnot saying, I don't have malpractice, they just canceled me or something like that. That's a great way to build a practice, right? I don't have malpractice insurance because no one will give it to me. Or they just canceled it or something like that. But please make sure you know about Rule 1.4. 1.4 on the malpractice issue. We're not going to talk much about that no matter how long we go today. But it's very important for those of you who are out there and don't have malpractice insurance. It's very important for you to know that, to know what that's about. But Rule 1.4 is more about other important things than the malpractice. Rule 1.4 is the communication with your client. Okay? And that is so important. I sit in my office every day, and I have 3 part-time secretaries. We do well in a small town like Newcastle. I mean, we're not rolling in it or anything like that, but we're paying our bills, at least today. We paid them on Friday. I don't know about today. Anyway, I tell every one of my clients that, and they really beam up when I say this. Everything about your case that comes into or goes out of this office every single time will be sent to you so that you'll know exactly what's going on in your case. How can you possibly keep a promise like that? And again, this is the benefit of evolution through our practice right now. And we'll go and add more ornaments to the tree, but it's easy now. How many people, their postage crashed, how much they were spending postage, now that we do emails? Everybody does emails, right? So my favorite piece of equipment in our office is our copy machine. And it's not the copy part, it's the what? The feeder, where it's scanning everything. Okay? So that scanner, somebody just sent you 50 pages of interrogatories, and that gets scanned, jing, 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 jing. You can hear it going through that machine. It goes into a file, and it is immediately emailed to the client. Immediately, the same time we look at it. And we don't even spend that much time looking at it until they schedule an appointment to come in about that, but instantly they get it. Now, Rule 1.4 says you need to keep your client informed. And you could have a lot of problems when somebody says that I didn't know that the negotiations were going bad, or I didn't know this was happening or that. It is impossible for you to ever have someone make a really viable claim against you ethically in 1.4 if you give everything to them. So, gee, that sounds easy enough. Well, why don't people do that? Well, I think people don't do that because sometimes they're afraid that they made a mistake and they're going to get sued for something or whatever. Which brings me to another point, too. Again, hovering above the trees, we'll land in some of these issues later. Brings me to another point. The Titanic, okay? I love the Titanic story. It has so many object lessons from it. They say, they say that it was the largest moving on the face of the earth man-made object at the time. And it probably was. It was unsinkable, but it sank in an hour and a half. Now, my daughter, Annie, I have 3 daughters, and the youngest one, Annie, she's the feisty one. She's a volunteer fireman. She's a senior in college. She has all that turnout gear on, so she's amazing. She played boys football. Anyway, I love her. She's just passionate about everything. But she's passionate about that, too. She was passionate. She did this huge college paper on it. She'll disagree with me, but I'm going to bend it a little bit here. That if the Titanic had hit that iceberg head on, it probably would have ruptured only one compartment in the front of the boat and would probably still be somewhere as a museum right now, or maybe even still being a treating. Now, Annie can tell you about brittle tensile strength of the metal rivets and all that stuff like that. But so where we take that in our office as an object lesson, we tell people if you made a mistake, and it's going to happen, we're human beings, you need to tell your client immediately that you made a mistake. Or maybe I didn't make a mistake, but it sure looks like I made a mistake. But you never hide something like that. You bring them in. You send them notice. You tell them that they could probably maybe even want to sue you or something. Now, why would anybody want to tell somebody to sue them? Well, I would rather have somebody sue me. I don't want to be sued, but I would rather have somebody sue me than have somebody take my license away from me, right? It's a question of mitigation. I could be sued and I could lose something and my malpractice carrier covered or whatever. I'll recover from that if I'm still in the game, but I can't recover from that if I can't practice law anymore. That's really, that's what I'm saying. These rules we're talking about here is to protect what you worked so hard for. Remember how hard it was in law school. And remember how hard it is when you get out of law school. And remember all those little faces that pop up in your head here, of all these people that need you. I say all the time that there's at least 9 people I know who are really glad I graduated from law school. If no other reason, those people need you. You have an obligation. You have an obligation to protect your livelihood. And so the best way I know to protect it is to be candid. I don't, knock on wood, that's a particle board, but I don't remember being in a situation like that. But I remember thinking I was in a situation like that. But the first thing I did is brought them in and told them, you know what? You have a right to sue me. And you can sue me and you can call somebody and get a second opinion on this file. You know what they said? I would never dream of suing you. I want you to stay in the case. We'll work it through together if it turns out bad. People are not looking to sue somebody, but I'll tell you what, they really go crazy when you kind of hide something from them. And you know what? Going back to Abraham Lincoln, we have several. I brought this little quote book there. Several things there. One of my favorite is, "No man has a good enough memory to be a successful liar." So even little lies lead to big lies, and all at once you're stuck. This is an extreme story, but it is a true story. I can remember when a made-up name, Harriet Swanson, there's a real client behind that, called my secretary to ask if I had filed what I said I was going to file. And I didn't. I didn't want to tell her I didn't. But I didn't want to lie either. We put her on hold, and I sent my secretary to the prothonotary 15 minutes away, like a bat out of hell in the car, so that I could pick up that phone. It's ringing back, and he'll be with you in a minute. He'll be with you in a minute. When I picked up the phone, I said, yes, I filed it, and I wasn't lying. Okay? I mean, that's an extreme example. There's plenty that we don't like to own up when we didn't do something we promised, but it's more important to say I didn't do it, and please forgive me, or go file it, but never say I did, okay, when you did it. It just doesn't work. And there's a case in our county in which a guy sued somebody, and I think what happened was he missed a statute of limitations, or maybe he missed preliminary objections or a motion for summary judgment that was granted, something along the line. But it was clearly he didn't even respond to something. It wasn't that good of a case anyway. The guy called and asked like a year and a half later, how's the case going? Oh, it's going pretty good. We're talking right now. We're hoping to settle it. Guy called another 7 months later. How's it going? Oh, we're getting close. A year later, he finally says, yeah, we settled it for $10,000. The attorney actually went and got a loan and gave the guy $10,000 to say that's what he settled the case for. The attorney's not practicing law anymore, you know. That's certainly. But I don't think he started out meaning to do that. I think it just gets a life of its own and pulls you away from. I like to say that I have my faults, and I don't think I'm the brightest bulb on the Christmas tree, but I'm not afraid of anyone. I'm not afraid enough of anyone to lie. I mean, I can take it if you want to say I'm stupid or you should have done something, but I'm not going to ever lie. You're not going to get my dignity. So 1.4, you can head all that off by just sending them the bad news right away. They're not going to fire you. They're probably not even going to sue you. But be candid. And nobody can, even if they could sue you, they can't take your license away from you then. So 1.4 has a whole bunch of more things to say as we continue into the depths of the ornaments that we're putting on the Christmas tree. 3.1 is a rule to pay attention to. Meritorious claims and contentions. 3.1, has anybody in here ever had the experience of some lawyer sending you a letter saying that you filed something that's frivolous, and by the way, I'm going to sanction you and your client? Anybody have that? I've had it happen 3 times, I think, in my career. I don't know what that says about me, that nobody out there ever had it happen. It happened to me 3 times. But it does? Who said that?
I did.
Yeah, it happens a lot. And by the way, the first thing I do is I don't say, oh yeah, meet me in a street and I'm going to knock you on your ass or something like that. You know, I mean, I want to, but I don't say something like that in a letter. By the way, there's anybody know an attorney out our way called Alexander Lindsay? He's from Butler. He represented the, after the other attorney, he replaced the attorney on the football coach thing in Penn State. What's that case called? Yes, the Sandusky case. Al takes all these high-profile cases, and he's representing that guy. But he's usually pretty well known out our end, that's for sure. Anyway, there was a lot, by the way, we all know that everybody is entitled to due process. There's a lot of major things that were done procedurally in that case that leaves a lot to be desired. If you ever have a client that's a criminal client, you shouldn't let them make speeches before the preliminary hearing or before anything while the case is going on. I mean, that certainly doesn't help. But aside from that, meritorious claims. Mr. Lindsay and I teach CLE classes. He won't drive 5 hours to come and teach you that. I'm the only one goofy enough to do that. But Mr. Lindsay always says, give me an argument. Give me an argument. I'm going to make an argument. I can make something out of that. Give me an argument. Well, 3.1 is that frivolous argument. So Al always also says he has this 10 commandments of law, how to practice law, the 10 commandments he calls it. And it's really neat. There's some neat little things. And he calls it the 10 commandments because he has a little story next to it. And because of the little stories, you will always remember those 10 rules he teaches you from the little story. So he's an embellisher like I am. But one of his rules is that you don't put all kind of nasty stuff in a letter. Somebody's going to read that letter eventually. And when they read that letter, nobody likes a smart aleck. I mean, you know you want to tell somebody off in a letter, but I'll get a letter like that. I have got a letter like that. And the first thing I said was, wow, thank you, counselor. As an officer of the court, I appreciate that you're bringing that to my attention, that there may be something lacking in what's going on here. Although I do want to remind you that I have an obligation under 1.3 of diligence for my client, and I do have a responsibility to be a zealous advocate on his regard. I am going to take this under advisement and have this sent out for a second opinion, and I'll get back to you as soon as I can. Probably take me at least 30 to 60 days, and we'll determine whether or not what you're saying should be revisited. You know, it's very polite. It's what you should do, quite frankly, because somebody might come back and say, this really is way over the line, it's frivolous, and therefore you shouldn't do it. Or you bring the client and say, listen, this thing is really close on the call here. I'm going to do this, but I want to make sure that your representation contract says that if I get sued, that I never knew any of these people until you walked in my office. You need to be aware, even to defend, indemnify, hold harmless. I mean, nothing like that would be improper if you say that I don't have to take this case or I need to stay with it. But all those things are things you should actually meet with the client for, and you certainly should explain to them, going back to 1.4, that somebody might someday sue them because it was frivolous, because they sure as heck wouldn't want to be surprised with that information if it happened. It's happened to me 3 times. No one has ever pursued any of that in light of the letter I sent. In fact, what happened was 2 weeks after I sent that letter, the last time it happened, they filed POs. So they kept it going, you know, and none of it was a preliminary objection in there. So what's really neat is the comments in Rule 3.1, and hopefully I'm going to go back to them. And that's page 50, by the way. But this is so powerful, this language in 3.1. Provides that a lawyer may not file a suit, assert a position. Remember that now. They're starting to put more than just file a suit. Assert a position, conduct a defense. Get that one. You can be guilty of frivolous even if you are defending an action. I don't know how you could do that, but that's what the comment says. Delay a trial or take other action on behalf of his client when he knows or when it is obvious that such action would serve merely to harass or maliciously injure another person. That's the first sentence on the comment there. Again, the comments are really cool for you to spend. Knowledge is power. Okay? And then it goes on to say, with 3 qualifications. First, the test of improper conduct is changed from merely to harass. I'm going to skip that part. The advocate has a duty to use legal procedure for the fullest benefit of the client's cause, but also a duty not to abuse legal procedure. The law, both procedural and substantive, establishes the limits within which an advocate may proceed. However, now this is where it really gets kind of cozy for us again. However, the law is not always clear and never is static. Accordingly, in determining the proper scope of advocacy, account must be taken of the law's ambiguities and the potential for change. The filing of an action or a defense or similar action taken for a client is not frivolous, merely because the facts have not first been fully substantiated or because the lawyer expects to develop vital evidence only by discovery. So think about that one. Now we know a complaint, that little fancy phrase, plaintiff believes and therefore avers. Plaintiff believes and therefore avers. That's, I can see the faces on some people. It's magic. I know, I use it too. I believe and therefore aver that a comet's going to hit the earth in about 2 hours, okay? You can't go that far, but the plaintiff believes and therefore avers, okay? But that's magic in a complaint. Even if you don't have the evidence to support that, if you think you can find it with a good faith is the overriding thing here, that you think discovery can produce that, then throw those believe and therefore avers all over in there. Those are like magic. They survive preliminary objections. They survive motions for summary judgment. They survive motions for judgment on the pleading. Every complaint that's written by anybody should have believes and therefore avers at least 5 times in it. Okay? So, again, I'm going to read that to you again. The filing of an action or defense or similar action taken for a client is not frivolous, merely because the facts have not first been fully substantiated or because the lawyer expects to develop vital evidence only by discovery. So, again, make sure your complaint has at least 5 believes, and therefore avers in there, because that would already take you past frivolous. What is required, again, of course, don't you love it when they start debating with themselves in their own comments, you know. What is, and the little man on each side of the shoulder, what is required of lawyers, however, is that they inform themselves about the facts of their clients' cases and the applicable law, and determine that they can make a good faith arguments, or can make good faith arguments, plural, in support of their client's positions. Good faith, support of the client's position. Now, you can't say believes and therefore avers if you don't know what your client's talking about, because you didn't interview them. And we're going to go into that, by the way, too, how we're going to pull all this together under one little roof here. Such action is not frivolous. Wait, let me hear this one. Such action is not frivolous even though the lawyer believes that the client's position ultimately will not prevail. How's that one? It's not frivolous even if you believe he will not ultimately prevail. The action is frivolous, back and forth, right? The action is frivolous if the lawyer is unable to either to make a good faith argument on the merits of the action taken, or to support the action taken by a good faith argument for an extension, modification, or reversal of existing law. So, when you find your back up against the wall, you need to tell the judge that you actually have an advocate duty under 1.2 and 1.3 to argue that this law, in this set of facts, is unjust. I just had a termination proceeding the other day. It'll be a week tomorrow. And there probably were 90 cases where this lady would be terminated justifiably by the judge. And there's 2 or 3 cases in which there were not terminations. And I told the judge, I said, Your Honor, this case is the not termination case. This is the head note on why you shouldn't terminate a case. And if termination could be done in this set of facts, then I'm arguing that the law should be reversed or modified. So not only do you have a right to do that, you have an obligation to do that, quite frankly. And brings me to another thing that I feel really good about, and I've heard my son do it now too. It's really neat when you find your son starting to do things that they don't even know that you told them to do it, because they don't think their fathers know anything, right? But passion is an important part of who we are and what we do. I can see why I teach these CLE classes. I can't tell you how I see people come in and, man, they want to be here anywhere near there, and they don't even like what they do. There's so many lawyers I see that are unhappy. There are so many judges that I see that are unhappy. There's more judges I see unhappy sometimes than lawyers. And the first thing I know they have a tough job, but I don't think anything ever justifies being mean to anybody or embarrassing somebody in front of their client, for goodness sakes, or in front of the rest of the system. I think one of the biggest strengths I have in being a lawyer, if I have a strength at all, is that I know what rejection is, and I kind of ignore it. It's like kind of gasoline to me. I've been yelled at before. Teachers, assistant principals, football coaches, I've been yelled at a lot. I don't care if you're going to yell at me. I don't like it. Nobody wants to be embarrassed in front of their client. But I'll take that. But I am not going to keep my mouth shut. I'm the only person this person has to mouth an argument, give something to it. So it seems to me that if you can't passionately represent your client, then you probably have a bad client or a bad case and you shouldn't take it. Or if you can't passionately do it for any of them, then you might want to consider doing something else. Because quite frankly, not only are you hurting them, it's hurting you. I like what I do. I don't like the stress. Nobody would. I don't like the bad things. The thing that's worst of all, in being a lawyer, and I've overheard another attorney in a hallway in Allegheny County where it's chaos sometimes. Somebody asked him, "How's it going?" "Yeah, depends on the client, who they are, and what mood they're in." And doesn't that sum it up? When a client turns on you and tries to stab you in the back and say you did something, or you said something, or you should have done something, and all they're doing is armchair quarterbacking you later, I mean, that betrayal really is a real bad part of this business. I mean, I don't like that. That comes with the territory. But for the most part, I kind of like the rest of it. Without the pressure, of course. So that comment, would you read through the law on the meritorious claims? Probably, but very few of you have read the comment. And the comment is empowering. It really is. So the next rule that we're going to be talking about is 3.2. Just touching on it, expediting litigation. Expediting litigation. There are two rules. One is a counterpart in criminal law, 570. Anybody who in here ever in your life or now criminal law at all? Great. Okay. And you're also a Montgomery County guy?
I practice in all the counties in federal court.
Oh, you're a federal court guy.
Both.
Okay. I'm kind of like still intimidated by federal court, where there's shiny hallways where there's no people. It's all quiet. All the doors are shut. Back on our end of the state, that's what it looks like. I kind of think I'm not so sure they have anything to do. I don't know what's going on. But I know when I walk in federal court, they have these calendar things that, man, they're going to, right? I mean, that's the one thing they do.
Rocket docket.
Yeah, rocket docket. That's the expression I've heard. But in federal, now, Mr. Lindsay that I was talking about, he does a lot in federal court. But rocket docket, yeah, you got to be ready to move. But anyway, in criminal law, the counterpart in Pennsylvania is Rule 570. I'll bet most attorneys don't even know what 570 is. There's a civil counterpart. It's Rule 3.12 on our pretrial conferences. Okay? And we'll get into the details on that a little bit later. I do want to read you 2.2.3. In any action, the court, on its own motion or motion of any party, direct the attorneys for the parties to appear for a conference to consider simplification of the issues, necessity, desirability of amending the pleadings, possibility of obtaining admissions of fact and documents which avoid unnecessary proof, the limitation of number of expert witnesses, the availability of a preliminary reference all issues to a master for findings, such other matters as may aid in the disposition of this matter. To me, a real lawyer's lawyer is the lawyer who gets the parties in front of a judge and starts honing in on, okay, if you prove this, I know I lose. But if I prove this, this could be bad for you too. Why should we risk either of those results for our client? And you have that kind of a conversation with a judge. You know what? No problem with this? That kind of conversation usually takes place when you're picking a jury. But Rule 2.2.3 says you can do it any time. We make it a habit in our office of filing a motion, sometimes even after we file a writ, to make the parties show up at court. And you get that back and forth, both attorneys in a little room and reporting to the judge on where you're at. And I'm telling you, you can settle a lot of cases a lot faster with a lot less litigation under that rule. And in 570 in Pennsylvania, it's very much the same type of thing, that if you have issues and whatnot. Now, the prosecutors don't want you to do that, right? The prosecutors have this, now I know in our side of the state, I don't know over here, but our prosecutors, they all go to these seminars, and I think that's why they all learn how to do this stuff. Our prosecutors in Allegheny County, they'll have some appearance, arraignment. Then you appear for call to trial, they call it. And they basically tell you, here's our plea offer. Take it or pick a jury tomorrow. And boy, that creates a lot of anxiety with your client. They take it out on you. You didn't tell me it was going to be this bad and blah, blah, blah. Yes, I did. You're just not remembering. But they only have... So if you go into Rule 570 and get yourself a conference away from the cattle call when they have all of them packed in a room and they're saying, listen, I don't have time to do this. I got 50 files here. And you can get a separate day, you can probably get some stipulations and get some agreements and maybe even affect the plea bargain. But those are two very, very, very important rules, one civil and one criminal, and they spring to life under you telling everybody you have an ethical duty under 3.2 to expedite litigation. So anytime, I can tell you right now that I had judges in some counties, I've been in 32 of the counties in 67, I've had some judges basically just write denied across it. Don't you love when they write denied right across your order and big X through it, like this is so ridiculous, I'm not even going to tell you. I'm just going to send you something that says denied. You could flip it over and with your fingers read denied. He pressed so hard on it. But there are some judges do that because they don't want to have even more conferences. So, some judges, some lawyers, some people just don't even like doing what they do, and they would do less of it, so they don't want to do more of it. So anyway, that's 3.2. And like I said, the criminal counterpart is Rule 570. And I think the last rule that we talk about here is Rule 1.16, terminating or declining representation of a client or a file. Emphasis on purpose. Terminating or declining representation of a client or a file. Where I come from, I have a guy, for example, who'll fax me everything that happened in his life the prior week and thinks that first original representation contract means I'm his attorney. And of course, we know our ethical rules can basically be stretched that way, that you didn't have a very clear contract. So it's very important. What do we know first? We know that if you decide to take a case, you should be taking a case with a what? Ethical violation? Written contract, right? It's unethical in Pennsylvania to represent a client without a written contract of representation. Now, it's better for you if you get them to sign it, but not signing it doesn't make it fatal, but it is very much a problem for you if you don't have a representation written contract with your client. So my secretaries know every time somebody sits down to have that boilerplate documents laying there and they sign that, sometimes you get talking and you leave and you're all excited or not excited or tearful or whatever, but you want to make sure that you get them a written contract, and be a good idea to get it signed too. But terminating a file is also a problem. So get in a habit of letting your client know that I'm assuming responsibility for nothing unless we have a separate contract for each separate thing. You know, that doesn't mean if you have a divorce, you have a separate contract for custody, a separate contract for support, a separate contract for the property settlement. I don't mean it to that degree. But anything that is distinctly different. And terminating is important. Do you know, a brand new attorney taught me this, and we've been doing it for about 5 years now. We actually have a consented motion to withdraw signed in the file the day a client hires us. A consented motion to withdraw. And we have several things on there. You failed to keep appointments. You failed to keep the payment schedule. You failed to do this. You failed to do that. You failed to follow our advice. All those things are in advance agreed by the client to be basis for withdrawal. And then we don't have to run and track them down and we can withdraw. But I think even if you can't withdraw, you need to attempt to withdraw when your client is going off the rails there to draw that line between you and what they're doing and whatnot. Now, part of our retainer, by the way, builds in what we call termination of the case. Withdrawing, successfully marking the docket satisfied if we close the file, successfully closing the file in the office in the settlement, bless you. So the termination of the case, even successfully so, you should be building into your retainer. Now what is a retainer? It's what you get paid. And again, like I said, we're not going into depth, the overview here. The retainer, the law is very clear that there's two components to a retainer. One, what you're going to do for the client, but number two, and this is the one nobody seems to remember, your availability for the client. First of all, if your client hires you, you know the other party can't hire you, so you've already eliminated a potential client. Number two, you know if your client hires you, you're going to have a certain amount of work on that file and responsibility, and you're not allowed to take more work than you can handle because that's an ethical violation all by itself. So being available is part of the retainer, okay? And the law allows you to say that even just signing the person up, you're entitled to be paid for that. Next, it's the responsibility you have assumed, okay? Every single thing that you might do wrong, that client can go to your malpractice carrier and get reimbursed or paid if you harm that person. So your malpractice insurance needs to be paid, and it can only come from the people that you file a representation for. So the first thing I do is I explain to them what a precipice for appearance is. If I'm taking your case, I have to send something to the court. I tell a client, you know what that means? That paper took probably about 5 minutes to make, but it has to be filed and it has to be served. But it also means I'm responsible now. I mean, until I withdraw, and I have to get permission of the court to do that, right? Until I withdraw, I'm responsible for your file. So the fact is that you have now taken, there's only so many chunks of me available. You're now one of my children, okay? One of the people I'm responsible for legally. So assumption of that responsibility to the exclusion of everybody who has an interest that conflicts with you is something that you need to be paid for, regardless of what you do for it. Just having that and being responsible. And they never have to worry about somebody doing something in court that you don't know about because I'm your attorney now. The prothonotary is required, the clerk is required to give me notice of everything. So it seems to me that no retainer should be less than about $2,500 just for signing on as the attorney. That's at a billable hourly rate about $275. Over on the other side of the mountains and whatnot, what's the what do people normally charge per hour around here? 300? Okay, I knew ours was ancient. We've been doing $275 for a long time. We don't get it, obviously, all the time, but that's what we have the right to bill. And 300, I'm hearing 300 and plus in downtown Pittsburgh. Now, is Philadelphia, do you do a lot in Philadelphia? So that'll be average in downtown Philadelphia? I always thought it'd be higher.
350.
350, okay. Okay.
Larger firm would bill 450 to 600.
By the way, they have to, almost. Yeah, and why? They have fixed overhead, right? That's another advantage of being the small guy, being the small girl, being the small attorney. You don't have fixed overhead. You're only spending money when you're being hired, and when you got, like, God, some of these law firms have 300 lawyers in them. We got involved in some fracking cases out west. Do you guys have any fracking issues around here? We did a lot of municipal planning on land use appeal, substantive validity challenges to ordinances, nuisance claims and whatnot. The fracking stuff is all over the board. And I think we have one of the only cases still left. Well, actually, it's not left. The Commonwealth Court, we had a fracking case. I'm going to divert here just a little bit. We had a fracking case where it started out as a zoning issue. Any zoning lawyers in here? Anybody do zoning law? We do a class on zoning, by the way. That was the mayor who called me because he wants to see me because he wants to fight city council. That's just what I need to get involved in a fight between the mayor and city council and have at least one of those two groups, probably both of them at the end of the day, hating me, okay? And I have to live in that town, okay? But anyway, zoning is really a weird body of law. If you live in a residential area, you probably like the idea that somebody can't put an adult peep show next to your house, okay? And that's because it would be inconsistent, although there's a lot of constitutional issues there. Bad analogy. Let's say auto body repair next to your house. So, because that is inconsistent with the neighborhood. Now you have to step all the way back off of that and recognize that everybody in America has a right to do whatever they want with what they own. So that flies in the face of a free country, but there are exceptions to freedom when it hurts somebody else in zoning law if the zoning law was enacted before the person was using it to offend the rest of the neighborhood. This case we had made it a right to put a well pad in your yard. Now, I don't know if anybody's ever seen a well pad, a fracking well pad. Anybody here ever see a fracking well pad? Wow, nobody. Oh, they're immense. Maybe that's because of us, out there, Dante and Pulaski. Those things are amazing. You go through the mountains sometimes, and if any deer hunters in here, or people who just walk around the woods once in a while, you walk up there and you hear some noise, and you say, "What the heck was that?" You're way in the middle of the woods, and you'll see one of these things going like this, that they're they're pumping oil or whatever. Some of them go clear back into the 1800s, big pipe going through the mountains and no other human signs anywhere. They're not peaceful little extraction devices. They're like as big as this hotel, the flattened area, and then they penetrate the earth and all the rocks with this BB of liquid that has all kind of things in it. Nobody knows what's in those things. And then you release that stuff, and they have these flares and whatnot. Oh, they're amazing. So the case we had was that this particular township, which was pro drill baby bill. John, listen, I'm not a tree hugger, and I'm not against tree huggers, and I'm not a drill baby drill person either. I'm a person that thinks that there's a middle ground in this thing. But the drill baby drill people had a zoning ordinance in this very high class area in western Pennsylvania that said that they are as of right. Okay, what as of right means is you don't even need to get a permit off the local municipality, generally speaking, to just put a well pad there. Now, I mean, if you have a special exception or a variance or something like that, you still have to come before the board and get it approved, and those people can say, okay, you're not going to be drilling 24/7, you're not going to have exploding flares going on every once in a while when it vents gas, you're not going to do this, you're not going to do that. But our case stood for the fact that you shouldn't be able to get one as of right. And ours lasted through all the cases being struck down from people stopping or impeding the drilling process. And it was in Commonwealth Court, and the Commonwealth Court made us appear, and they had an argument, and then they impaneled the whole court again almost a year later, and we had to go back for a second argument, which seems to me unprecedented. And then eventually, on a 5-4 decision, it was against us. And now it's at the state Supreme Court on zoning issues. So, in all of that stuff, it talks about, nobody would have anticipated it would go that crazy. And if you don't have your representation contract sound and done, I mean, you're going to be stuck in that case for a long time. And terminating, you need to have permission, and you need to show that there's nothing pending and all that. So 1.16 talks about terminating, and then 6.1, my last one in our overview, is the voluntary pro bono service. I have no problem with doing pro bono work. I've done a lot of it, not intending to be pro bono, but I have no problem but I do have a problem with doing pro bono work when a person has absolutely no stake in the case, and they're really, really hard to control. They're mean sometimes. They don't respect your work. So that's where, the contract of representation says that if you don't follow the rules of our representation, we can withdraw or decline your case. So I think it's important to make sure that they do it by the book, schedule appointments just like everybody else, and do that. So what I'm about to tell you that I think that has value is that a simple practice management plan touches on every one of those rules. Absolutely. And it's really kind of neat. And the first thing, and I don't know, notice the computer guys don't even put their head in here anymore. I don't think they want to know if my computer isn't working. I have to get a pen out of my briefcase here. And you might want to pull out a pen and that thing I handed out to you, because we're going to kind of like stretch a little bit and have some, less talking at you and more interaction. we have a document here, and anybody not get one of these? You walked in late? Okay. The name of the client is Joe Baduca. Did anybody hear of Joe Baduca? Joe Baduca was a guy that apparently had several friends, and he was a name dropper. Joe Baduca told his friends, "Hey, I know the mayor." "Oh, yeah, I'm sure you know the mayor." And of course, Joe Baduca calls the mayor and says, "Mayor, these people don't believe I know you." "Oh, yeah, Joe, how's it going?" Blah, blah, blah. Anybody over here? Okay. And Joe Baduca says, "Yeah, that's nothing. I know the governor, too." Is it Tom Wolf? Tom? It's telling that I don't know his first name, maybe. I don't know. Is he from your end of the state or ours? Middle. Oh, the middle. Okay. Anybody else? Okay, so Joe Baduca, he goes to the state house, and sure as heck, Tom Wolf comes out and says, "Joe, how the heck are you?" Anybody else? And Joe, the guy was really flabbergasted that Tom Wolf knew him. He says, "Yeah, I know the big T. I know Donald Trump, too." He said, "Absolutely not." So Donald Trump's in the Rose Garden, and of course, Donald Trump sees Joe Baduca and waves him over and puts his arm around him. This guy says, "I know the Pope." Right. So, of course, they go to Italy, and the guy is standing, Joe Baduca is standing in this crowd, and I want to make sure I don't blow the punchline. I did last time I tried. It's too early in the morning. Okay, so Joe Baduca is standing there in the crowd, and so the guy who's been flushed out, he really does know these people. He's unconscious. People are looking at him. He's in Vatican, and he says, when Joe Baduca said he knew the mayor, I didn't believe him. I was shocked. When he said he knew the governor, I didn't believe him. When he said he knew Donald Trump, I didn't believe him. It sure as heck it's true. I said, but I was down among all these thousands of people, and some nun came up to me and said, "Hey, who the hell's that up there standing next to Joe Baduca?" When he was standing next to the Pope. Anyway, that's who Joe Baduca is. He knows everybody. But anyway, this was like 11 o'clock last night. I needed a name. Joe Baduca came into my mind. Okay, so I am showing you whether a lawyer, or whether a lawyer that's a merchant, or whether a lawyer that's helping somebody, one page that encapsulates just about everything I just showed you. One page, okay? Now, what do we know about contracts? Remember I told you I hand briefed all my cases? I remember Hadley versus Baxendale. Anybody remember Hadley versus Baxendale? Offer and acceptance, right? Do you remember the case from law school where the guy makes an offer? What does that guy do? He just created the power of acceptance in somebody. So the case was about, I can't remember exactly all the details. The case was about somebody making an offer, and the guy didn't accept it. And then the guy making the offer was trying to run away from the guy who was the offeree. And the offeree ran up the steps, and the offeror slammed the door or something. And the offeree yelled through the transit, "I accept!" Okay? What happened then? Right? Contract, right? Offer, acceptance, consideration. Don't we learn that? How crazy was that your first year of law school, that book was got to be 10,000 pages at 0.6 type thick. You have one test. I'll never forget how scared I was for that. All about offer, acceptance, and consideration. The three things that go into a contract. Anyway, offer and acceptance. Okay? Now, most people, the offeror and the offeree in the beginning, like each other. They really don't have a problem. If you've written a good contract, you know what happens to that contract? Nothing. It goes into a file cabinet and nobody ever looks at it again if it's a good contract. Right? And what's a good contract? A good contract is something that is less about binding and more about reminding me what I promised. What you promised I was going to get and what I was going to get. Now, Dante, for purposes of our skit, this portion, when I start holding this up, is the backbone of this course today. All of the other stuff is just the many ornaments hanging on this tree. This little thing here is going to come back over and over and over again, this little page. Okay, so let's talk about what a good contract is. First of all, it has the offeror and the offeree's name, right, at the top left-hand corner. In this case, it's Signature Hill. That's what we call our mansion, by the way. It's that old George Johnson man. We call it Signature Hill. I don't know. It was just an idea. We didn't want to call it Angelo Papa's mansion, Angelo Papa's money pit, Angelo Papa's folly. It's Signature Hill. We thought it'd be kind of neat to, your signature is who you are is more important than what you are, okay? And Dante, remember that years ago we made a video like that. Anyway, so Signature Hill is the offeror. Joe Baduca is the offeree. Beside Joe Baduca is like some kind of a file number. So if you're a successful business, you're going to have more than one offeree. Okay? These are the important elements to a contract. Go to the extreme left, and this is really important in a law office, the start date. Okay? Remember that hypothetical I told you about the lady who wanted me to represent her in a divorce, and I said, give me $500 and I'll get started? You know how that translates into problems for you already? 3 weeks later, Harriet Swanson calls and says, beep. Yeah, Jeannie, my secretary. What? What do you want? Harriet Swanson wants to know what's going on with the case. I said, who's Harriet Swanson? Okay? Harriet Swanson, that lady who gave you $500 2 or 3 weeks ago, and you can't remember a clue what that's. Already you got a problem, okay? So, Harriet Swanson, I think it'd be a good idea when you determine you're going to work for her to tell Harriet when you're going to start. Okay? That's another thing in a good contract. This little piece of paper is its own little Christmas tree. One of the ornaments is the offeror, the other ornament, the offeree, and when you're going to start. Now, we know underneath that, end date is always going to be something hard, but we should have some kind of an idea, and this is important to make sure that that is in there. Now, if you have these things and have a start date and keep your promise and have some kind of a reasonable end date, you already have the makings of a nice arrangement between you and the offeree. Now, we now get into, what are you going to charge Harriet Swanson? Okay, well, this to me is so important. It defines who we are in our office. If there's anything, any defining moment, it's who we are. It is the most giant ornament on this Christmas tree. Maybe it's the power cord that lights the whole tree up. We take the time during the initial consultation to sit and listen to the facts. And when you listen to the facts and you have a procedural awareness, Rule 213, right? Rule 570, complaint, whatever, when you take the time with that client, now you want to control the interview. Remember I told you we're not going to sit there and listen to every detail in their life in which they're going to tell you everything about their life. Why? Because you're being hard on them? No, but because you have a responsibility to the other people who call you their attorney, that you can keep your schedule somewhat under control. Maybe schedule another appointment if they want to talk to you more. But you have to control that interview and get to the salient facts. When you have those salient facts down, you'll sit there and start to realize, okay, this is a divorce. This person didn't charge with crime. This person wants to get rid of that knucklehead she married, okay? I now can rule out the 570 conference, the shiny hallway in the federal court that our colleague talked to us about. We now are starting to narrow things, okay? Okay, Harriet, when did you marry this guy? I married him on blah, blah, blah. When did you separate? Were you separated? Blah, blah, blah. I have the salient facts in that. Notice up here by tasks, it says phase, okay? Now we know that in this business, it's hard to predict how the other side is going to respond. We know that it could go all over the place. So that's where Rule 1.2 comes in, scope of representation. Rule 1.2 tells you that you are entitled to limit the scope of your representation. That doesn't mean you quit after phase 1, but you clearly identify, listen, I'm going to get you started, and then we're going to take the temperature, and we're going to see where it's going from there. It's possible this guy's saying, that's the happiest day of my life that you filed for divorce. I want it more than you do, and there's very little work. We don't know that. Or it could be somebody all at once that just wants to fight over everything. So for right now, let's not go there. And on our task list, let's make sure that the person knows this is limited by Rule 1.2 to the following tasks only. Okay? You're allowed to do that. Now, I think it would be hard to defend. I said I would draft the divorce complaint. I never said I'd take it to the courthouse. You have to pay me more for that. Okay, that would not be, consistent with the rule and the comments on 1.2. Okay, so you have tasks, and over here you put phase 1. Okay, now you have the complaint for divorce. These people aren't married and don't have kids, so I'm going to keep it just for purposes of illustration. Now, we know that we have to serve that document, and we have to file that document, and we also know that we have to prove we did that. So it's going to require us filing something at the courthouse and certified mail and everything. So you might want to put 1.5 where it says serve and 1.5 where it says filing. And we don't need to go to motion court. They have motion court in, what's that county again you guys said you're from? Montgomery. They have motion court down there?
Yes.
Okay, so motion court, where most people that's a whole little journey itself.
It's not quite the circus that Philadelphia is.
Yeah, well, I'm going to take a minute here. I love to tell these little stories, motion court stories. Allegheny County. Have you ever been in Allegheny County motion court?
No.
Okay. Well, I was in motion court in Allegheny County. They have several different motion courts. First of all, each judge seems to have his own motion court rules. And I was in motion court, ran to Allegheny County. Now, it's an hour and 10 minutes to get from Newcastle to Pittsburgh, and you got to find a parking place. Running up the steps. Lawyers lined up forever for motions, okay? And I remember in there, and I won't say who the judge was, but he came in, and he normally came in from lunch. He had an afternoon motion session. He always wore one of those little hats that snapped on the peak, Is that a Big Apple hat or something like that they call that? And he had his trench coat on. He would just stand there, like when people were bringing their motions in. He didn't even take his coat off. Some guy ran around. So all the unopposed motions line up first. Nobody's here. You just walk through, stamp, 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 sign, stamp, stamp, stamp. You're out the door. Take all the unopposed motions first. And so I was sitting there waiting my turn. I was opposed, so I had to wait. And about 10 minutes before they're ready to finish unopposed motions, some attorney comes around. Judge, Your Honor, oh my goodness, I had a hard time parking my car. You signed that order for him, and I'm opposed to it. And so the other attorney says, Your Honor, motion court is well known that motion court and all the local rules, he had it down. Right? Do you ever have one of those guys that says, these freaks that memorize the local rules and they can recite them off the top of their head? I'm sorry if I'm offending somebody, but it says here, Your Honor, blah, 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 and he wasn't here and you signed it. And quite frankly, Your Honor, you signed the order. We have a signed order now. So the judge said, can I see that? And he reached over and took the motion, and he went and he rolled it up and bounced it off his chest and said, I just unsigned it. Okay, true story in motion court. I mean, that's how motion court is in Allegheny County sometimes. But anyway, going back to our tasks. Because we're not going there, we don't have motion court. But why are these things here? Pleading, serve, filing, motion court. These are reoccurring themes, by the way. In this particular general practice of law, usually you're going to have a pleading, you're going to have filing, you're going to have serving, you might have motion court. Consultation and preparation, let's put an hour in there for that. Can somebody actually do this so I can get it? And somebody who has a phone with them with the calculator, okay? Is anybody following along? I'm going to double back a little bit. 3.5 for the complaint, 1.5 for serving, 1.5 for filing, 1 billable hour for consultation. Somebody with me? Who's my secretary? Anybody volunteer, please? Okay, just note it on your paper, okay? so that I screw it up when I'm doing it on a computer. Imagine what I'm doing in front of a room now. Okay, now we always know there's miscellaneous, what I call wiggle room. So I put 2 for miscellaneous and 2 for various correspondence. I've been doing enough divorces that I don't need to put notice, research, proofing, hearing preparation, discovery. Again, those are common things, but that's basically the list of our tasks. Okay? Now, over here on the right-hand side is the costs, which aren't ours, they're out-of-pocket costs. Now, in your representation contract, it should say that out-of-pocket costs to a third person are the responsibility of the client. I strongly recommend that you say, you understand now, something to a third person is your responsibility. It's also your responsibility to pay it up front. Now, I know the PI guys don't do that, but you never want to be stuck in a case where somebody isn't paying you and they expect you to pay $5,000 out of your pocket for some expert opinion. So you want to say it's your responsibility for out-of-pocket expenses, but it's also your responsibility to do it up front, or I can withdraw, so you're not stuck in trial. Okay? So, now, filing fee is certainly something that has to be paid. So let's put filing fee $100. Now, can somebody out there tell me what the total number of hours is? So we're now down at the bottom right-hand corner where it says total hours. Who did that total? Can you help me?
11 and a half.
What?
11 and a half.
Thank you, sir. 11.5. We know that the hourly rate is $275. We also know that there's $100 in out-of-pocket expenses. So on that next line, you have to put $100. And so can somebody multiply 275 times 11.5 and add $100? Da, 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 da. I feel like I'm in Jeopardy. You hate when I do stuff like that, huh?
$32.62.
Okay, $3,262.50, right? Okay. That's with the $100 filing fee. Okay? Now, that phase 1 is possible that if there's not a contest, all that's left to do, and again, that'd be on another task list, or if you want to cut the person a break, you can say, by the way, I'll do the affidavits and waivers, I'll do the precipice and the decree, blah, blah, blah. Whatever you want to do on here, you can give them whatever free stuff you want, but you want to make sure you tell them, I'm giving you this free stuff, but not the rest of your life, representing 7 generations of your family. Or you paid me $500 and now I'm going to do everything there is in this divorce, including fight an international custody dispute and study up on the Hague International Convention. By the way, you know why am I saying that? Because it happened to me. Okay, almost had to wear a powdered wig in Calgary, Canada once. Okay, so there's all kind of things happen when you're not precise. And they're not good. So now, I always like to go back and give them what I call a CBA. The CBA is a cost-benefit analysis. How much do you dislike this guy? I hate him. Okay, so I don't think there's any price on that, but that's benefit. Number 2, there's a retirement. There's a house that you have $100,000 in equity in. Starting to see the benefit now and the analysis compared to the cost. And by the way, we're going to try, because he makes more money than you, we're going to try to get counsel fees reimbursed, APL, alimony pending litigation, or something like that. Can't guarantee that, but we're going to try that. So at the end of the day, we show them that's a pretty good deal what I'm about to do for you to get this thing started. Because you know what? In Pennsylvania, you can't be divorced until at least 90 days has elapsed from the filing of the divorce complaint. Okay, so now phase 1 looks like it's how clear is that? Okay, it's very clear. And Harriet says, gee, I was hoping you'd keep the cost down. Listen, I can take things off of this list. I recommend not doing it, but if I take them off the list, it's going to drop the hours and drop the price, but it's also going to say that you're going to need to pay the second phase, maybe sooner rather than later. I don't mind working, okay? But nobody likes to work for free. You can't afford to do that. Your secretaries can't afford it. Your family can't afford it. You're letting everybody down when you do that. And you're doing it in the name of kindness to this person, but how kind are they when they're expecting you to just go home with stomach cramps because you don't know how you're going to make your loan payment that week on your student loan or whatever? As long as it's reasonable and fair, and they get this. Now, let's talk about other benefits from doing this. They understand something they never understood before. Do they understand what a precipice is to transmit the record? No. But they know that these are the things necessary to get them divorced. We know this starts the 90-day clock running, and many divorces will end right here. Okay? And so they got one piece of paper that says all of that. It says, I'm going to file it tomorrow at noon. Whatever date that in there. So all those little magic things on here, it started with who the offeror is, who the offeree is, the tasks that they purchased. If you purchase more tasks, okay, then the price goes up. But we don't think you should purchase more tasks for right now. Let's take a look at what happens, because it's going to have to be served and we're going to wait. This is our start date. This is the phase. How many phases? Well, 110 phases, okay? No, you have to give them some idea. This is phase 1 of 5,000 phases. No, it's phase 1. If it goes, this may be out there in the future, but for right now. Now, what have you done? You've allowed that person to start the litigation process without being afraid. Now, let's take a divorce away and say it's not a divorce. Somebody sued me and got rid of me as an employee. And I think that they should be sued for that. If you're asking me to put everything here that this case might go to, I'm going to need 50 of these. And you're never going to litigate. By giving a reduced phase and see what their reaction is, including maybe even settlement, you're giving them a chance. We can't guarantee what's going to happen, whether they're going to win, but we can guarantee what will happen if you don't do anything. Right? We know if you don't file anything, I know how that turns out. So you have to have that candid discussion with your client, and it's a very workable way. So we've got the phase, the tasks, the total, and then we have the out-of-pocket expenses, and we again say limited to these tasks only. Okay? That gives you an opportunity, Mrs. Client, to evaluate the file and see how it's going. It gives you an opportunity to evaluate me and see how bad, I told you I was the greatest thing since sliced bread when you sat down for our conference, but maybe I'm not, maybe it's just me. Maybe I'm some guy that's just braggadocious and I don't do anything right. But this is a fair, humane way to start. And then, of course, we know that if we don't go beyond this, that's okay. And we tell clients, $275 an hour, they're scared to death of that. But if you tell them, this office will never collect one more dollar off you unless you pre-approved future work with another one of these. Okay? Some of the benefits, obviously, this takes something that's very hard to describe in terms of what you charge and why, and makes it somewhat recognizable. Now remember, too, in our business, you need to make sure you tell them that some of these tasks may change like that, and some of this may need to be substituted. This is an estimate. It's only an estimate. But it's probably better than any other attorney has given you. I gave you something, some piece of paper that I tell them, okay, you got four options right now. Your first one is the big R. Run like hell and pretend you never saw me. It's a free consultation. There's 24 windows in this mansion and 5 doors. Nobody's going to keep you from going anywhere. I sat and gave you 2 hours. We've gone 3 hours sometimes. I gave you 3 hours and told you what, in my 35 years experience, what it's going to take to win. And even that may not be a win, but I'm telling you what your chances are. We do that for free every single time a client comes in. Now that is a defining thing for our office. And I'm not so sure I learned that in law school. I don't think I did. I'm not so sure I learned it from any other attorney. I don't know anyone who puts in writing what they're going to charge, but also puts in writing the limits of the representation. This would survive 1.2 scrutiny. If I got all of this done for that amount of money, that's giving the client something pretty valuable. So at the end of the moment, when that's all said and done, I can tell you how it's played out for us. The first thing that's happened is some people say, yeah, let's do it right now. Here's my card. We're going to get into cards, by the way. Here's my card. Bless you. So the first thing that happens is they accept and they're happy. That happens most often. It really does. The second thing that happens is somebody says, well, I want to think about it. And we say, fine, take this and shop around to any other attorney. Obviously, another attorney might see what the plan is. You know what my son calls this? When he sends it to people, he calls it an action plan. Because guess what? That's what they want. They want an action plan. What are you going to do for the money I gave you, and when are you going to do it? And what might happen after that? It's an action plan. So the next thing it is, we have other attorneys that work for us, and we know that some law firms have 300 lawyers and their hourly rate is higher, right? Because they have to cover that paycheck every single Friday, regardless of the number of clients. So this allows us to accept work, and these little things follow the client jacket everywhere. I gave Billy Bob, the new associate attorney, this file, and I expect that tomorrow these tasks be done. Okay? I don't need to. How many times you hire somebody? Anybody ever hire anybody to help you do some of your work? You end up telling them more about how to do it, and you end up giving. First of all, by the time you tell them how to do it, you end up doing it yourself. Or by the time you get done, it's cost twice as long. And pretty soon they're in the office, and you know they can't really do it. You don't really explain it. You don't have time to do it. So now you're starting to give them busy work, and that's pretty stupid at the end of the payroll, every Friday. So this allows you to assign the tasks to somebody else. By the way, you want to make sure you disclose to the client that I'm not doing everything. I'm the supervising attorney or whatever. Maybe they want only you, but that's something you work out in talking. But it allows you now to assign these tasks and track these. And your staff knows now, when these are all checked off, that the client needs to come in and talk about, are we going on or are we withdrawing and no longer being responsible for your file? If you do it and turn it around quickly, they're always going to want to know, okay, what's the next phase? Usually there's only 2 phases in a divorce. The last one is minor, unless somebody actually goes through an equitable property hearing. Now that could become a little bit more, because if you litigate the property issues, you need to have a pretrial statement, 1920 inventory of assets and things like that. But that's for another day. One of the other variations on this is Helen Swanson says 2 weeks later, oh, we're in love again. And they decide to reconcile. By the way, I shouldn't say only female. Bill Swanson says, oh, we're in love again. It's symmetrical here, So Bill Swanson is in love again. So Bill Swanson says, I want my money back. You didn't get me a divorce. Okay, where on here does it say you get your money back because I didn't get you a divorce? Did I do this? Yes. Did I do that? Did I do this? Did I do that? You don't get your money back. In fact, I probably caused your relationship to be saved. We can force a person to go to marriage counseling, and I can't tell you. I always give them the old parable of the seed thrower, by the way. And I'm not wearing religion on my shoulder. I'm not a preacher or anything. I'm just telling you a way to express and identify myself. I sit there, and Harriet says, gee, I don't know if I want to be divorced or not. Okay, Harriet, do you want this relationship, the style you're living in, to continue? Oh, I definitely want to do that. Okay. So you want to end at least the relationship that you have, the quality of that relationship, yes? Yes, okay. So by filing a divorce complaint, what's going to happen, he's going to respond and say, great, I hated her from the day I met her, and that wasn't worth saving anyway. And we have secured all of your financial interests to keep him from embezzling the marital estate, taking loans against his retirement, and buying gifts for some new girlfriend, okay, or vice versa. Or he's going to respond and start bringing you cakes, flowers, sending messages, singing to you in the parking lot when you pull up for work every morning. By the way, these are all real cases in my life, okay? And he wants you back because he realized, sometimes people don't appreciate something until they're about to lose it, for real. And this is pretty startling, right? Wow, my wife's getting rid of me. We've seen that happen. we have seen a huge number of cases, a large number of cases, not huge, back that back, a significant number of cases, because of the divorce complaint, have created happy marriages. That while it's hanging over people's heads, you don't have to do the rest of it. And by the way, there'll be stale cases that come up on the docket. They'll tell you it's about to be dismissed. You can renew it and whatnot. I have seen marriages saved by this. And the quality of the life that was spawning the will to be divorced kind of dissipated. Then going back to the parable of the seed thrower, right? So you throw seeds and some of it grows into a giant tree. You throw seeds on the path and it sprouts right away. But because there's no depth and no soil, it withers right away. The guy was doing cakes and singing in the parking lot, but he really wasn't serious about reconciling. He went right back to his old ways. And so she was glad that she just finished it off then. Or the other one where he hated her anyway, and it was about to happen, and so it's a good thing we got it. So either way, the flexibility of this plan has allowed that person to do that. And that's why I think quoting a phase of work is always better. And by the way, they would rather you do that than cost out a 3-year divorce and tell them what your retainer needs to be. Okay, so do we get it? The other advantage is that people leave and come back later with grandma, aunt, Billy, uncle, cousin, and say, I want to do this. Do what? Remember I was in your office last June? I'm sorry, I don't. But I do when I see this. You can remember it. You take some notes. I can't tell you how many people come back months and a year later and decide to buy the plan. Or somebody comes back 2 weeks later and has somebody else finance the plan. And of course, you need to talk to them ethically about, and there's a rule for that, when somebody pays for the representation, that does not mean, okay, that does not mean they can control the litigation, right? You want to tell them that. That doesn't mean they're even entitled to information on how it's going or what's happening unless the client permits that. And you might want to have them reaffirm that every so often, periodically. So that's another benefit of this single document here. Okay? Now, we call that somewhere up in here. We have a website that we call it ePlanQuoTract. It's editable. It's a plan. It's a quotation. And it becomes a contract, all in one document. Now, if you write down ePlanQuoTract, www.eplanquotract.com, we give that software away for free if you want it. And you can download it. And by the way, you can put your own name up there. You don't have to put Signature Hill or whatever. But we don't sell things in CLE classes, but it's going to help you significantly control your practice because it's going to help you with your clients and it's going to help you with cash flow because a lot of people I know quote a retainer and never get paid a thing after that, even though there's months and months of work after that. Rule 1.2 is so important for you to explain to them that I am not on call on this case the rest of your months and years and weeks. You need to define what you're doing. Now, it's entirely ethical and proper for you to say, give me $50,000 wherever it goes and I'm your man. So if you think about it, though, if you're forced to live with whatever your guesstimate was, what are you going to do? If you have any degree of savvy preventing your office from going under, you're going to quote it high, aren't you? So you're doing a disservice to the client in a way, doing a disservice to you if you don't. Now remember we talked about pro bono as we were summarizing our rules here? In my experience, it may not be yours, the people who got free work off of me treated me worse than anybody who paid me. They treated me worse. Maybe they figured he doesn't even respect what he does. I don't know what's going on. All I know is they treated me worse. It's people who really treat you worse is people that you say you're not doing it for free, but you never collect. Now, there's a chemistry that you see in that. I've seen this cascade of bad outcomes from that. The first thing that happens is you're starting to get a little short with them. You resent it. You can't help but not resent it. They call you whenever they want. They never schedule appointments. They walk in, they fax stuff to you. I emailed you that. Did you get that taken care of? What? I'm not your indentured serf, okay? So they can sense that you're getting near the end. And you know what they do? They quit on you before you can ever get paid. And what do? They figure you're going to tell everybody in town who they are, so they need to badmouth you first. So they tell everybody they quit on you because you're an idiot and almost screwed my whole file up. And so now, some of them go so far as to turn in a disciplinary complaint against you to really throw a rear guard at you and keep you off of their trail, and now your license is in jeopardy from somebody who never paid you. I've seen it. I've seen it go that whole cycle. And now something else I'm starting to see, I'm glad I'm getting old enough to maybe not do this much longer. This social media stuff, when they tee off on an attorney in Facebook and Twitter and stuff, we've got an attorney in Newcastle. He's a person I don't like at all. We fight all the time just because he's a mean little guy. But I do feel bad for him. Somebody's bought a website and they're just out there trashing him all day long, and now other people are joining it. Man, I hate that mob mentality thing on social media. Even people that I have despise their political views. I hate that. That's something that's so unfair. You know, people who do something for a living and they're trashing you and nobody else reads the rebuttal or whatever. And how can you possibly rebut it anyway? So, I think this always keeps it in place. There's no strings to bind your hands if my love can't bind your heart. When this phase is over, we can go our separate ways. And we're happy with each other. You don't have some gigantic fee dispute thing going on. Do they have a fee dispute committee in your county, in that county we've been talking about? Okay. Fee dispute committees. I run hot and cold on fee dispute committees. I've seen, how do you pass upon competitor attorneys in town? 3 lawyers, and I know I've seen fee dispute committees where they basically think they're a customer satisfaction bureau rather than a fee dispute committee. You know, well, I wouldn't charge for that. That's not the issue, whether you charge for that, okay? That's not the issue. The issue is whether they agreed to pay it and whether it is, if you want to go back to Rule 1.5, clearly excessive, okay? And 1.5, when we go back in more depth, will tell you what is and is not clearly excessive. And it's one of the longer rules we have. It has about 15 things that determine what your fee is worth. Anybody here remember Benny Hill? Yes, I love it when I get a few nods like that. The old guys, okay? Thank you. Benny Hill, those of you who do know Benny Hill, who he is, I'm asking you to remember there was a skit once where he was doing it. He was apparently an accountant or an attorney. But Benny Hill, rarely those skits had any sound to them. The scene was he was sitting in a conference room with his elbows on the conference table and his chin on his hands like this. And the lady, you could see the back of his head, and every once in a while they would show you his face, just like that, glimpse. And this lady is crying. She's daubing her eyes. She's frantic. She's explaining, and she's standing up. She's all animated and whatnot. And behind her is this clock, and it shows it's 10 to 10. It's 10 after 11 now. And she's starting to calm down, and she's doing this to him, you know, like he did so much for her. And she left, right? And then the camera went to the face shot, and he went like that with his eyes, and he had painted eyeballs on his eyelids. He was sound asleep the whole time, and he got up and there were plastic hands bolted on the conference table. It was a fake, the conference the whole time. We know that there are people who do Benny Hill consultations where they're not listening to a damn thing the person's saying. They're twiddling on the computer, ripping open the mail, you know, maybe not that obvious, but listen to them enough. Now, if you want to control them, maybe tell them about salient facts, flying 35,000 feet. Control the interview. Give them a real interview. And that's going to be giving them something. And I can tell you this too, those little notes you scratch out, when they become a client again, it's 3 weeks later. It happened to us 2 weeks ago, a year and a half later. Somebody emailed this to us from another state. Did we remember it? No, but we had those notes. We scanned the notes and we scan all these and keep them in a little dumpster file of sorts. And just that fast, it brings you back. I can tell you that I've been doing this for 35 years, and I don't think I have a great memory, but it seems like I don't forget. I'll forget names. I'll forget names when I walk out that door if I met any of you. Please don't be offended by that. I forget names. But I don't forget fact patterns, like Hadley versus Baxendale and all those contracts cases we read. Fact patterns. I remember the case where the guy was singing in the parking lot. Again, so that I can have a little bit of fun, I got to tell you a little bit about that case. That case is a very volatile, and again, Dante, we're both Italian Americans, so we both have that Southern European passion thing going on, and all those weird things, and he's Southern European too. You probably even know him, but I won't tell you. I'm not allowed to, client privilege. Anyway, he would send her cakes. He would show up in the parking lot and sing to her. Bouquets of flowers. She didn't want to hear it. And she wanted to be with somebody else. You know how that turns out. When they get it that you don't want to do it, they get mad then, right? So he got mad. He heart of gold, but he just had a temper that was crazy. So I'm 32 years old. It's my first time in court, ever. I was an assistant prosecutor because my cousin hired me. He was the DA. This was one of my first private clients. I didn't have e-plan quote tracts, by the way. I did have something. I think he paid me $1,500, which to me was staggering. I'm going to pay $1,500 to go to court for a couple of minutes. This is so cool. I'm so glad I'd be an attorney. I'm glad I did it. Okay. I'm thinking that's going to be every day, So we go into court, and it's a PFA. Everybody know what a PFA is? Some of you don't practice law. Protection from abuse. Okay? And we go into court, and the Honorable Judge Francis X. Calleja, okay? And he was a common pleas judge who just retired federal court. Anyway, she said, Mr. Pepa, I understand that you have worked this case out. They like it when you do that. Yes, Your Honor, we have. This is Mrs. So-and-so and her attorney. What is your name? Blah, 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 blah. How old are you? Blah, 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 blah. Mr. Pepa is going to recite the terms of this agreement, and you listen carefully. Go ahead, Mr. Pepa. Your Honor, my client does not admit to any of this. Not admit to any of this. He does agree, however, to stay away from her for the statutory period, to have no contact, and at the end of that period, the case will be dismissed, and everybody goes about their way. And so he says to her, he says, do you agree to that? Is that what you agreed to? Yes, Your Honor, as long as he stays away. Ma'am, are you clear-headed today? Yes. Are you here drug-free? Do you don't have anything clouding your judgment? Right. Do you understand the terms of what we just said? Do you have a colloquy, right? To make sure she understands knowingly, intelligently, voluntarily. He goes over to my client, my first time in court. He says, Mr. So-and-so. Yeah. He goes, yeah. Already I'm in trouble. Yeah, to the judge. He said, did you hear me say what the terms are of that to your wife? Yes, sir, I heard. Are you here drug-free and no prescribed or non-prescribed medication clouding your judgment to knowingly, intelligently, voluntarily agree to this and follow through? Yes, sir. My heart's beating a little slower. And you understand that you will have no contact with her. And that means no indirect contact. No more sending messengers to her employer with bouquets of flowers. Okay? I'm going to just turn it off. No more letters. No more cakes. No more minstrel groups outside in the parking lot. No. Oh, yeah. Did it all. This guy was putting this big stuff forward, He was making a major play to get her back. No more gifts on the doorstep of her house. No more cards under the windshield wiper. I don't even, it reminded me, remember the movie My Cousin Vinny? When Hamilton, what's his name? The guy who was in Car 54. What was the judge's name? Was Judge Haller, right? He says, you even clear your throat. Yeah. Remember, he says, I don't even want to hear you clear your throat. The judge says, I don't even want you to send a smoke signal up in your backyard. There'll be no communication with her. Do you get that? I'm going, Yes, Your Honor. Oh, okay, $1,500. All right. Great. I had an Armani suit on. I tell everybody usually my entire net worth is usually on my back. So his hand goes up, like in school. Looking at the corner, oh, God. So I'm ignoring it, right? When you ignore stuff that you can. Denial is a river in Egypt and a good legal strategy sometimes, right? So the judge says, Mr. Papa, yes, Your Honor. Your client has his hand in the air. I know that, Your Honor. Put your hand down. He goes, I need to ask him something. You can't. Mr. Papa, he can ask me a question. Okay. I sit down. He stands up. Your Honor, you know how you said I can't send her cards? Yes. You know how I said I can't send her birthday cakes anymore? It's 2 questions now, right? It turns into about 10. He's colloquying the judge now. And you know how you said that's for a 3-year period? Yes, Mr. So-and-so. I almost said the name. You'd know it if I said it. Yes, Mr. So-and-so. He says, he like looks around me so his face can meet hers. He's already violated the order, right? Make it 100 effing years, he says. On the record. Court reporters typing, this is a true story. First day in court. So I looked at the judge and I went, oh. So the judge didn't say anything. He says, all Mr. Scully? Is that all Mr. Jesus, it came out. Dante, you got to delete that. I know. They don't know him, but you have to delete that. I said, he says, Mr. Papa, please explain to your client that the jurisdiction of the Court of Common Pleas does not last 100 years. Court adjourned and he walked off. Yeah, true story. So, anyway, you never know what you're going to say in court. You never know what you're going to say. And I have several more stories like that. We're not going to bore you with all of them. Okay, so that takes us back to the quotation. It takes us back to a practice management tool. More importantly, it takes us back to a tangible, clear understanding. And although it's not the perfect answer, it goes a lot further. And hey, what we do is so hard to quantify, to sell to people. It's all we have is our time. So it's a reasonable estimate, and they don't have to do it. So, and again, like I said, if you go to that website, I guess it's www.eplanquotract.com. www.eplanquotract.com. You will find there you can download it for free. www, World Wide Web, the letter E, Plan Quo Tract. Plan Quo Tract. Okay? It's editable. It's a plan. It's a quotation. And it's a contract. That's where we get Plan Quo Tract. Okay? Now remember we were talking about Hadley versus Baxendale and meeting of the minds? Okay. Let's go to this. You print this thing out, hand it to her, and she goes, oh my God! Okay. And you say, well, what'd you expect? Were you planning on paying anybody anything? Well, yeah. What'd you think you were going to pay? And she says what she thought she was going to pay, and you went, oh my God! Okay? Both of you, oh my God, at each other, but what do you know? You know there's not a meeting of the minds. Right? So now it's possible you could say, well, listen, I'll cut this down a little bit if you want, but if I cut it down, I'm going to need to do this sooner or later. Or, there's nothing wrong with this either, and very encouraging you to do this. Say, okay, I'm not going to charge you for this thing. I'm going to do that for free. But what have you done? You've shown them that you're doing that for free. You're not doing everything for free. And you've given them some idea that there's a bit. I've just cut you a heck of a break here. And you at least get a pat on the back for it instead of them trashing you later. And you have that documented. Okay? So you have the minds met. Now, there's a lot going on in the bottom right-hand box, too, by the way. This is less about the form and more about tying all those rules together. Okay? The bottom of that box avoid you from running over to the window in your office and peeking what kind of car they drove up in to determine what the fee is going to be, right? That's a crude joke. Nobody does that. Hopefully you don't. But at some point in time, you don't fill out a needs analysis to determine what their fee is, okay? So we basically say there are two types of payment plan. First things first, we accept payment in three ways. We prefer cash, not because we're going to cheat the government, because we know that's negotiable, and that's immediately deposited. Anybody ever deposited a bad check? Okay. Secondly, we will, as a courtesy, accept a check. And we almost always get paid checks and cards. Nobody pays us cash. But we tell people that's what we prefer, so at least they could say they got a break. They didn't have to pay cash. Okay? I'll explain to you where that's going. And we will accept charge cards. Is there anybody in this room who actually their office accepts charge cards payments? Anybody? Nobody. You do? Ma'am? You do? Okay. I didn't mean to put you on the spot there. Okay, I'm going to tell you about that in a minute here. Okay, so we accept paid in those three forms of payment. We have two basic payment plans. First of all, this is an estimate of our time. It's also an estimate of the tasks. It's pretty solid, but it's an estimate. I mean, don't try to wrap that around my neck someday. Back to my math guy. Sir, can you divide 3267.50 by 2? $3,262.50. $3,262.50. Well, I need exact. I'm going to do this exact. I'm doing this the right way this time. I'll show you why in a minute.
1,631.25.
Okay, so they can pay $1,063.
1,631.25.
$1,631.25. And we tell them that's the half. We're not doing anything beyond that half unless you pay us the other half. No, you don't do that. We're willing to trust you. You're going to pay only half of that. And we're going to do the extra work, but you're going to be billed on some structured payment plan on the second half of that fee. And this is an estimate, and it suggests that, you know, it might be more on that back half. Let's get that straight. That's your standard retainer, which most of you are doing right now. Now, this is a personal thing I do, and most of our clients really like it. Can you go into your computer, your phone again there, and hit 3,000. Well, actually, is that still on your screen?
No, sir, I'll redo it. It's fine.
No, just multiply it by 2.
3262.
Yep. Okay, now times 0.20.
65.25.
65.25?
Yeah.
You mean only $65.25?
6,525. You asked me to double 3262, right?
No, I asked you to do 3,262.50 times 0.20.
Oh, I'm sorry.
That's okay. Anybody else do it already? That's okay. We'll wait. It's okay. Gives my vocal cords a little rest.
$652.50.
Okay, $652.50. Now minus that from 3262.50, that original number. Just hit the minus sign and minus 3,262.50.
2610.
2610. Now I'm sorry. Thank you so much for your patience. I appreciate it.
fine.
Okay, so this is something I do. You may not want to do it, or something I do. If you avoid us having to send bills, and if you pay it all up front, we'll give you a 20% rebate, which in this case saves them $625.50, so they pay $22.10 for this task list. This task list is capped, and they got a 20% discount. So they have 3 ways to pay, 2 payment plans that are fair, emphasis, I'm willing to give up 20% any day not to bill. I hate billing. Okay? So I have to tell you, 90% of our people like that discounted thing, you know. But be very careful. It's these tasks only. Well, you said I was paying a flat fee for the rest of my life in every piece of litigation I ever bring to your office, you know. Obviously, that could have some traction. Okay, so that now gives you an opportunity to give some flexibility to people. And I have had people that say, I can only afford the half, but I would like the discount. Bring the difference in 30 days and we'll give you the discount too. But again, it all goes back to this idea that you're getting something for what you're doing. You're not just saying, give me $500, I'll figure it out. So, all because of that Benny Hill absent consultation, where you were paying attention, you have a good understanding with good business, and you actually have something that is fair. And I think it should be a rare day that you're being paid hourly that you quote a fee on everything. Unless you're just willing to eat a whole bunch of losing time. And even if they were pliable and respected you, at the end when they're no longer paying you, they can get really, you know, mean and whatnot. Okay, so let's talk about how that connected to these rules that we talked about. And I'm going to go back here. (1.1) competence. I think you've already declared that you're competent because you knew what you're doing. You told them what needed to be done. And you've actually given them a plan of action. You're familiar with the procedural route that they need to take to vindicate their substantive issues. And Rule 1.1 has some subcategories to it. It talks about thoroughness and preparation, maintaining competence, retaining or contracting with other lawyers and things like that. So you'll find a wealth of support in that little adventure there for competence, compliance. Rule 1.5. Let's talk about fees on page 18. A lawyer shall not enter into an agreement. Notice it doesn't just say get paid. Enter into an agreement for, comma, charge, comma. So even if you charge somebody an unethical fee and didn't collect it, you still could lose your license. Or collect an illegal fee or clearly excessive fee. Now, I think when they mean, and again, this is an I think moment here, which means that's not, you're all lawyers, you can figure it out yourself. But I think when they say illegal fee and then say excessive fee, that obviously an excessive fee would be an illegal fee. But I think they're talking about an illegal fee per se. Something like, for example, if you did a divorce on a contingent fee basis, that's an illegal fee. If you, I don't know. That's an example. I don't want to spend too much time on that. The most important part of my talking today is the excessive issue. The factors to be considered in determining the propriety of a fee include the following. 18, whether the fee is fixed or contingent. Okay? And we know that the standard is 40% on contingent fee cases, and that's been upheld over and over and over again. The time and labor required, the novelty and difficulty of the questions involved, and the skill requisite to perform the legal service properly. I mean, there's a whole bunch of things going on in that screams out yes for a 35-year lawyer, you know, who has a successful practice. I want to duck back up there on that contingent fee thing for a minute. On the contingent fee thing, some of you people don't do contingent personal injury work, and anybody in here ever refer a case to somebody else? Okay, and we do that too, and it's really kind of neat when you get a check in the mail, you even forgot you referred somebody to somebody. I have a good relationship with a couple guys, but all the comments seem to support the idea that you should actually be somewhat involved in the file. You know, if somebody decided to just say screw it. I'm paying you what you were going to get, and that referral you're sending to him. I think to be on the safe side, I would keep in contact with the client every once in a while, send him a letter. Remember, now, they went to that guy because they know you and they trust you. So you might want to maintain some degree of paper back and forth. Yes, sir?
The new rules require, when I sign a client that's referred to an attorney, that reference has to be in the contract.
Yes.
So I have to indicate to them that a portion of the fee they're paying me will go to the referring attorney.
Thank you.
So that is required.
It's actually in the rules.
It is in the rule, in my contract with the client. So if you refer, I represent dog bite victims. So if you refer a dog bite client to me, in my contract with the client, I have to put that out, that I'm paying you a percentage of my fee. So I have it right underneath my section of my cut. Underneath that, it says, so-and-so attorney referred to, a portion of my fee goes down.
So he's a referee, and if you're a referor, you should probably have it in your contract too. Remember, now we have to have a written contract with somebody. Don't put all the onus on these guys. By the way, we do a lot of work, and it seems like it's mostly hourly. We refer all of that kind of stuff out. When you just said that, I was thinking of a foul I had. Please let me know if you'll accept referrals from us. I mean, it doesn't mean you have to take it. We just send you the fact pattern, you let us know, you know. So, anyway, so let's move on. The time and labor required, okay? Now, I'm going to go into something else here that's very important, and I think that you should have a regular professional software in your practice if you're on your own, especially. I am not a salesman. I get no commission on this, but I use Time Matters. Anybody here have experience with Time Matters? It's a software. I'm sure they have other ones, but it has the basics that probably all of them do. Number one, you put the contact in there. You put the case referral. The dogs, phone calls, everything goes to that client file and all that stuff. It has an invoicing process where you hit mine has a little plus green sign. I'm going to make it green on purpose. You hit the plus and a billing invoice comes up. And it says what you did, you know, categories, letter, contact, pleading, etc. You can make your own categories. And you click that, and then it has a little comment box in there. And basically then you hit it, and it goes back into the client bill, and the hours are tabulated and keeps on going. What's really cool about it is there's a scheduling feature too, so that if something is on the schedule, an event, hearing, or a document deadline, document responsibility, that goes into our scheduling system. And then the reason why I didn't leave until 9:30 and get here this morning is last night I literally was back 2 weeks into our Time Matters going through the schedule. I just bring out the whole calendar and I see somebody's name. I click it, it opens up, and I say what I did, and that is done. You mark it done. It falls off the calendar and it goes right to the bill. You don't have to do any of that manually. It's all synchronized. Now, years ago, I started using something that I think I was way ahead of my time, and I strongly recommend it. I use, again, no commission or anything. I use Dragon Naturally Speaking. Does anybody in here use Dragon Speaking? Voice activated stuff? It's really cool. Except you have to worry about, sometimes it's a counsel of record. It might say COUNCIL, or tell that jackass I'll call him back later. That actually went into a letter one time. So don't do that with that wireless mic on your ear or something while you're walking around in your office, because if you don't read your letters over 3 more times, you might find a half of a sentence in there saying something like that. So be a little bit more disciplined than that. That actually happened. Anyway, but Dragon Naturally Speaking, what I do in the box, I will say by the way, the client came in and forgot her appointment for the 3rd time. By the way, the client was reminded again, we need an expert. And the client says they don't want an expert. I mean, these are important things for you to protect yourself from your own clients sometimes. I spend 30% of my time probably protecting myself from what they might do, okay? But there is nothing more powerful than a well-annotated record, but that takes time. But again, if you have a voice-activated stuff, you just bring up the invoice and you put a little narrative in there, you know. Sometimes I'll do that while they're in my office, and I hit the print button, I make them initial it, and they confirm that that's what we just talked about. You know, I think it's a great way to document your time and why that took you 2 hours instead of 3 hours or whatever. But that's what I was doing before I was coming down here. I went back to my office somewhere around 7, I think it was, and I didn't get on the road till 9:30. But I wanted to make sure I had that, downloaded that out of my brain into that computer because I knew I was behind maybe a couple weeks in diarying my file. I think it's important to do that at or near the time. It takes minutes to do it. Anyway, so that's item number 2, the time and labor required. The novelty and difficulty of the questions involved. Do you think the word novelty came up in that fracking case? Duh. Okay? And the skill requisite to perform the legal service properly. I put in the skill category the solution-oriented approach. Remember I told you about expediting litigation? When you file a Rule 212, 213.2, and make everybody show up in court and start getting to, even if that didn't result in a settlement, it's going to result in what their key issues are. And it's going to let the client know what his chances are. I think that that's way beyond being thinking outside the box. And you know what? Clients love that. The worst thing they hate is, when are we going to get to court? When are we going to get to court? I didn't hear anything for 2 years. What are you going to do this? What are you going to do that? They want to they want to go to the courthouse. So take them to the courthouse and make it valuable for you too. 3, the likelihood, if apparent to the client, that the acceptance of the particular employment will preclude other employment by the lawyer. Would we talk about that? You only have so much of you to go around. So if you're doing 10 files, I have a dear friend that's working, he's a doctor. It's part of my next class, by the way. Wow, we're moving right along. The doctor sees 40 people a day. This doctor sees 40 people a day to maintain his lifestyle. How can anybody see 40 people a day? He does. So clients need to know that if I took your file, you're keeping me from getting paid from somebody else. Not only if you don't pay me, is that not bad? That's bad on 2 levels, because the time I'm giving your file is keeping me from somebody else who would pay me. Okay, and that's right there in the rules. 4, the fee customarily charged in the locality or similar legal services. The amount involved and the results obtained. There are, in this book I gave you, there are hundreds of citations of cases talking about fee challenges and what survived for the lawyer and what didn't. You know, the most important theme in every one of them is the results. Every single one of them, fees are almost never challenged or successfully challenged if the results are good. And that's item number 5. The time limitations imposed by the client or the circumstances. I just had a person hire me the other day, and their case was this person went through 5 different lawyers, and he was on what's called the call to trial list for criminal cases. I mean, I had 4 days to try to come up with some kind of a reason why this plea bargain should not be accepted or why it should be backed off by the DA. That's something that the court allows you to charge for emergency work. The nature and length of the professional relationship with the client. That's probably the one time you can get away without having a written fee contract for something, is if they have a standard mode of operation with you over the years. The experience, reputation, and ability of the lawyer or lawyers performing the services. And then it goes under B, C, D, E. I'm not going to read them all to you. I'm hunting for a comment here. That same rule, by the way, goes on to the subheadings on basis for the fee, which are explanations of that enumerated list. Then terms of payment, divisions of fee, and again, disputes over fees. Now, by the way, going back into what you brought up, sir, at the end comment says, with regard to Rule 1.5, permits division of fees only if the client consents to employment of other lawyer after full disclosure that the division of fees will be made. The total fee of the lawyers does not clearly exceed what is reasonable. So it's right there in our comments too, what you just said. Thank you for that contribution. Now, we started at 8, and if we didn't have any breaks, we're supposed to get 1 per hour. So we're here 4 hours, so that's 40 minutes. 12 minus 40 is what? When? 11:20. Okay. So we are approaching the runway for landing instructions, just so you know we're about to start descending. Okay? So I know you're having trouble controlling the sadness as we approach the runway here. We do appreciate the fact that you have choices and you have chosen us to fly with. So make sure your tray tables are in their full and upright locked position, and we'll try to wrap it up and give you something that you can run away with, okay? Even though we didn't cover a third of what I wanted to cover because of all these personal stories. Sorry.
I have one question.
Sure.
Your form, do you use that in conjunction with an engagement letter?
Oh, absolutely. Exhibit A.
Okay.
Back in the, my engagement letter, we are going to work on it over Christmas. My son and I were just talking. Our retainer letter is 28 pages long. That's 28 pages of getting screwed, quite frankly. I mean, there's so many more things in there than just payment. About you will schedule appointments, you will follow through, you will do what we suggest you do, you will do that, you won't do this, you will do that, you won't do this, you know. I require all of our clients to schedule their own appointments. I'm a disaster with my own schedule. So that's a great question, and I was going to do this anyway as we approach the runway. But as an overview, we now know how they became my client. We have some rules in our retainer agreement. First of all is our communication infrastructure. We tell them that there is no substitute for an appointment. That if you call me out of the blue, you're probably going to be disappointed in my demeanor and what I tell you. I can't possibly memorize your file driving at 70 miles an hour headed down the turnpike. Okay? So I tell people, you don't really want my advice on something that crazy. The second thing is, it says that you personally are responsible for calling the secretary, who she's not a good lawyer, but she's a darn good secretary scheduling things. Very good. She's very good at that. So she's an expert at that. And you need to talk to her, and she looks through my schedule. She knows my court things. She knows what's going to be long and what's going to be short, and she's going to schedule you. So in a normal day, there's a couple things that I don't think you should ever eliminate from your personal jurisdiction. I open all the mail in my office. No one touches that mail, faxes or emails. If it went to somebody else, it still comes to me. I want to see it. I don't spend much time with it, but I want to see it. If it says that a pleading, if I get a notice to plead, the first thing I do is run it over the calendar and I count 18 days, not 20. I count 18 days from the time I got the notice to plead, 20 days, right? And I get that same letter and I write DDL and I put the date on it. My secretaries know that's a deadline. Okay? Something else comes in, the judge, there's a conference on December 28th at 10 a.m. Again, I take that page. The rest of the document goes into our scanning system, but I take that page and make a copy of it. There's maybe 7 of those. Last night I did this. There were 7 or 8 of them. Some DDLs, some scheduling. And they went into the copy machine. Paching, 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 paching. I got mine. I punched them. And I went and put them in my master's book. Now, I don't just write down judicial conference with Judge Swanson. I specially, on purpose, make a copy of the order itself so I know exactly what it is in case I can't remember. So I have to look up the whole file. And I know exactly what courtroom I'm supposed to be in. It's the actual order itself. There's a master schedule with all of them in our office right now. Now, the second thing I do with it, I go over to our dry erase board, and if it's blue, it's a document deadline. If it's red, it's a hearing. And it's a 2-month picture of my life in advance on that dry erase board. Just the name of the client. And I generally remember. The other two, remember I said I got 3 of them? The other 2 go into the scheduling girl. The scheduling girl scans them all and sends them directly and immediately to the client with a cover letter that says, you are responsible for scheduling an appointment before this event or deadline, no more than 10 days, no less than 5 days in advance. 1.4, punt, spiral, right? All that happens in minutes without my involvement. There's many times I go, what's he doing here? Well, he's here because he has a hearing 3 days. Oh, okay. No, take a peek at it, and we sit down and sketch it out, you know. So that's probably the most important part that goes along with this, and it's all part of this infrastructure on what we're doing. And so if you have the scheduling and the document deadlines, I forgot what your question was. I'm sorry.
Do you use your form in conjunction with a...
Yes. Yeah, I actually, many times, somewhere down here, I think it says approved. I try to remember to make them approve it. Then there's, at the back of that 28-page, that's where I got this. That's how I drifted off. Back of that 28-page document, there's a section called miscellaneous, and it would be referred to in the miscellaneous section. And it'll say 1.2 limitation on the representation. And I'm going back to the 28-page document, the scheduling thing. Also, we have something in there on charge cards, that's a courtesy. I'm going to make most of you smile who don't use charge cards, and I might give you some heartburn. Don't know if you guys know this, but they have these chargeback rules, okay, that most of them, it's at least 6 months, and some of them are a year from the time the services were completed that a person can charge back the fee. I had it happen recently. $8,184, I'll never forget that number. Just taken out of our account with no notice. Imagine the havoc that could wreak. Okay, so, and they have their own little rules, their own little kingdom, and there's nothing you can do. They won't let you talk to them. You just send them some kind of a file history, and you're trying to frantically put all that together. And there's only one paragraph there that says that the client says that you didn't do what you advertised you would do, or something like that. And I actually had conversation with the charge card people, and I said, I'm going to be teaching lawyers this week practice management, and I'm not so sure this is a compatible way to charge for fees. I can tell you this. I think it would be important, and we have it in our representation contract that the client has in advance, because of the courtesy of letting him use charge, promise not to use the chargeback feature, although it didn't work this time. They don't care about that. The other thing is maybe make sure if somebody's going to charge their fee that they charge smaller amounts on different cards, or even let them go to take the card to the bank and get a cash advance and come up and pay you. But that chargeback thing, if you think about it, at least 6 months after the services have been rendered, we're talking about a divorce that could take 2 years. Scary. But I'll be honest with you, it's a huge, good way when that doesn't happen to process, you know, because you call them and they like you, and you talk to them about phase 2, and you send them an email and they like that, and they authorize payment of phase 2. And we never keep numbers, by the way. We always destroy numbers. They say, well, just you run my card. No, I don't keep your card. You paid the first time. I never keep your card number. Never. Okay. And then you authorize it. But that takes us, you know, into the IOLTA account. You all know what an IOLTA account is? That's where you deposit that retainer before you earn it. Now, you should make sure in your representation contract that it says that without further notice, I will charge off of the retainer and pay myself as I go, without calling you every time I want to get paid. It does require you to earn that. I remember when I left the district attorney's office, I was making 200, wow, can't remember what it was. $200 some every 2 weeks as an ADA, part-time. All my friends who were school teachers and whatnot, they had those big pay scale raises back at that time. And I told everybody, that my ship came in, but I was at the airport when it did. Although I really got tired of teaching. I really did. So anyway, some lady came in and hired me to do a custody. I didn't have software back then. I used to do this on a piece of paper. And I think it was like $3,200 or something like that. And I said, I was so afraid that lady would call and fire me before I got a chance to earn that money. I stayed up all night doing all the pleadings, filed everything. She was so amazed that I actually did it so fast. She was telling everybody how cool I was. And I actually got a whole bunch of new clients. And it actually created a niche for me, which goes back to the task analysis and selection and getting it done quickly. Do it before they can take it back, if for no other reason. You know, get the work done. And by the way, they'll love you for that. You know, in our business, we have more brilliant people. And every class I stand in front of, I still believe, and maybe it's not right, my son always tells me, I wish you wouldn't say that, I still believe my students are always smarter than I am. But there is one thing I know. I know that if you get something done quickly and call people and stay in touch with them, you'll have all kinds of business. Our competition is with people who generally are not really working at this. So I like to tell everybody, man, this is pretty exacting, but I've got a solid work ethic. My parents never left us, their kids, any money, but they left me and my siblings a solid work ethic. And if you take a solid work ethic and you take passion and you put them together and have something that's reasonable and identifiable, you have the makings of a pretty cool business and changing lives. But you got to sit on it. You have to. There's signs above all of our workstations say, "Work your file, and it will work for you." When you do a task list, you almost always find something else, and they're saying, "Man, keep on going. This is great." And you bring them in, and if you work your file, it will work for you. It really. I have seen that happen over and over and over again. Okay, because that question was so good, I'm going to ask: does anybody else have any other questions or even a comment? Would love to hear you throw in some of your experience if you think that you have something to add. Anybody else? Or another one, that's good.
Just one thing on IOLTA accounts.
Okay.
In my firm, we have about 42 different IOLTA accounts in about 13 states. And not all banks are authorized to write an IOLTA account in that state. We didn't know that.
Wow, I didn't know that either.
Oh, yeah. The bank actually has to be approved by the state to carry an IOLTA account.
And can you tell your classmates why they have to be approved? There's some strictures on a IOLTA account.
I don't know.
Well, it seems to me, and I'm guessing on some of this, but the IOLTA account is something that is policed by the bank itself. For one thing, if it's ever overdrawn, the bank is required by law to immediately notify the disciplinary board. So even if you had money laying, by the way, it's against the law to leave your own money in your IOLTA account. You're supposed to take your money out of there if you've earned it. Now think about that one. Take all your money out of there as you earn it, and if you ever overdraw your IOLTA account, they immediately notify the disciplinary board that you must be spending your client's money. That's the first thing they're looking for. So,
And if they aren't reconciled every month, you can be reported to the disciplinary board also.
that's probably the biggest problem with disciplinary actions. They know that if you are disciplined, we can take you away from the consumers and you can't hurt them anymore. But the one thing they can't fix, although there's insurance now to these IOLTA accounts, which is the other most important reason, you can't get the client back their money. So that's another reason why we have insurance on that, but that's why they come down really hard on IOLTA account violations. And what does that mean, come down really hard? Okay, the first thing you would have happen is you probably would get a certified letter from your disciplinary board. I know the one in, I don't know, are they split in half in the state, or is there one for each half? I know in Pittsburgh, it's downtown Pittsburgh in the Frick building. Not because I was there. But they send a certified letter, and they'll usually send 20, 30, 40 sentences or something. We think that you may have committed a violation of the ethical rules. Please answer these questions. Now, this is not a time to say, I did not have sex with that woman, okay? This is not a time. because that denial that is disingenuous. It'll get you in more trouble than probably whatever you say in response to those questions. It is not a time to, go become fancy with words. But it is a time to be careful. For example, if you're like me and you have all kind of business, sometimes you don't remember. So what if you said something and it was inaccurate, but it's only because you didn't remember? So I think that you should precede whatever you say in answer to that with, to the best of my recollection and understanding within the deadline you've given me. And I know that you can get extensions if you need. This is my answer. I reserve the right to change my answer if my recollection changes. I think it's important to say that because you can get in trouble just, they think you were trying to hide something. But disclose everything, because when it's all said and done, you can continue to work. They usually, even if you made a mistake, it's better to fess up. Goes back to that Titanic thing, right? The boat would still be floating if it hit the iceberg head on instead of veering and ripping 7 compartments, flooding 7 compartments and sinking in an hour and a half because it tried to duck the hit. When I used to coach football, we'd have a contact drill in the first 2 days of practice. And if I saw somebody pull their nose out, I knew they weren't a football player. And it's maybe because they're too smart to be a football player, because they're not going to hit their head against something. But I'm just telling you, if you're going to avoid the hit, or if you're going to make excuses and whatnot, it's not a good thing. Stand up and be accountable, and be proud. If you take a look at all of the problems that we know, it almost always goes back to how they didn't handle the investigation properly. Everybody tries to duck it. We're all humans. We all make mistakes. So now let me take a peek here. If that spawned any other comments, feel free to chime in. Again, 1.2 is so important on that scope of representation. That is probably one of the most chief protection you have. Now, in your book, too, I am going to share with you a couple things that you don't know because we didn't get there. We have an actual fee brief that is in there. It's actually written. When you do anybody here ever do an adoption case? Adoption is one of those cases where sometimes you have to show why you charged what you charged, right? Okay, so we actually have a brief in here, an actual brief. If you see a name in there, it's only because by accident we must have left it in there. But there's one of those in here. And then we actually created from all the cases, and it's on page 115, we created our own little head note series. If you look up head notes and all those veils, do they still call them veils? All those head notes. We have forever bound, no contract, no pay, jurisdiction. We created our own head notes on page 115 and 116 and 117 and 118, 119. And then starting on page 20, on 120, we took those little phrases and expanded them into little head notes with citations. And they are not the most recent cases, but they are representational of what comes up in fee disputes. And then in the back here on page 142, we have actually some real-life hypotheticals applying some of those things. And then way at the back on 171 talks about the IOLTA account, and it talks a little bit about charge accounts. And you want to make sure you take a look at your charge machine. Remember now, if you're offering charge abilities, you're a merchant. So you want to check with they're all fighting to get your business, by the way. Ask them how anxious they are to defend you from an unscrupulous client that tries to take his fee back. There are companies, you can see it on TV all the time, that say, if you're not satisfied, you tell us. Okay? Now that charge card company is pandering to the retail customer and actually inviting them. You know, how many people do you know would be dissatisfied at the end of their litigation? 50% of them at least. Sometimes both sides are dissatisfied. And guess what they're going to do? Somebody knows that they can say something in one sentence and take all their money back? Holy cow. Talk about an invitation to disaster. But that's the standard operating agreement of a situation. I had an attorney in a class that we taught about a month ago who said that his charge machine is on a different account, and they immediately move the money into other accounts when somebody processes, so they can't take it back. Well, I kind of think that if they can't take it back and they try to take it back and you get frustrated at that, I think probably that voids your card machine and you never have it again. I don't know. But it's one of those things like where it's not fair, and I don't know what to do about it. So, but be careful is the most important thing. Be knowledgeable when you're doing that. And I think I'm starting to lean toward having our office say, go down to the bank and get a cash advance on your card and come back. You know. So we'll take cards, but I'm not going to be the guy left holding the bag. Yes?
How would this work with a flat fee?
Pardon me?
How would this work with a flat fee?
Okay, let's go with a flat fee. You have this thing here, okay? You're talking about a flat fee, one payment, and you're done, right? I think you should basically itemize all the things you're going to need to do, 5, 6, 10 pages, and at least show them, this is what I'm going to do for a flat fee. I may have missed a lot, but I think you should take the time to itemize for no other reason to let you calculate how big that fee should be, right? Civil suit. Let's give you an example. Civil suit. I file a civil suit against him. You know that that attorney is going to file preliminary objections. That's guaranteed. 5 defendants, 5 sets of preliminary objections. Amend the complaint, they all go away. They file new POs. We've amended complaints sometimes 5 times. And all that's going back and forth, and eventually you have an argument court with each defendant, and you're writing a brief for each one. If you're going to give someone a flat fee, make sure that you protect yourself and have enough in that flat fee, or talk to yourself and say, I promise to do it, and damn it, I'm going to do it. You know. So I think it's important, and definitely say on there, this does not include an appeal to a higher court. This does not include an appeal to the Supreme Court. A lady saying that on one of our fracking cases, I thought if we go to the Supreme Court in the United States, that's included. Yeah, right. Oh, but it didn't have it anywhere it wasn't, right? So this flat fee thing can work, but take some time, though, to think it through. And I think if you give them that and say, this is what it has to be, they're going to say, oh, my God. And they're not going to want to do it. And certainly you're not going to want to do it. And if they don't, then you might want to go back to say, let's take it in at least, let's get through the first 2 months and see what it's going to be. I'm willing to do that.
But that wouldn't work for immigration law.
Pardon me?
Immigration law.
Oh, okay, yeah. See, I don't do anything in immigration, but I think everything, the same thing, you might want to say in there that these are the things we're going to do. If you were a civil lawsuit, these are the kind of times. I sell time. This is the time I will have necessary for each of these things. I'm willing to charge you for only 50% of that. But this is where I believe, and they need to know why you arrived at that figure anyway. So whether it's this magic form or whether it's anything, it's written up as to why you charged what you charged, and they agree to do that. I have many times written off fees and not charged for the back half, but they knew what I was giving them at least. How about this one? You do a bunch of free work or an entire free file. When it's over, they sue you because you didn't do it right. Wow. They're out there. They're out there. I mean, it's a tough world.
Is your fee agreement, since fee arbitration requires mutual consent, does it provide for that in your agreement?
I don't say anything in there, but the fee arbitration does require mutual consent. But if you look in the rules, if you look in the comment of 1.5 in your book I just gave you, somewhere in there it says that the disciplinary board as a policy ignores fee issues because of the fee dispute. So it seems to me if you avoid this fee dispute and never agree, which you don't have to, then you're going to have them looking through all your fee issues and anything else that happens. I think I'd rather take my chance with some liberal, give them back everything you paid person, 3-panel lawyer than actually go into a disciplinary proceeding, you know.
So you would rather refund the fee or just waive it than go before an arbitration panel to get your money?
I've done both. I always tell people that within reason, the client is always right. If you come in and I show you,
Or a consumer.
yeah, if I show you what I've done, we knew it. But every once in a while, you get somebody who wants it all back and they just want to tee off on you and badmouth you. If they're going to do that, I mean, I'm going to fight.
In commercial matters, I go through the process. Get
Yeah.
a fee, or try to compromise, certainly.
Yeah, it actually takes you more time to defend yourself, and you could be charging $275 an hour to another happy client. So I calculate all that in there. But I do have a thin skin when somebody is bad-mouthing me and saying that he's an idiot and he didn't do this and he's a fraud or something like that. Man, that's my street side in me. The judge was yelling at me one time when I was a prosecutor, and I was scratching my forehead with my middle finger looking at him.
The bar and the disciplinary board are not all bad, so it's
They're not. They're not all bad.
just in fairness.
And in fairness, they don't want to disbar you either. They do want to correct you, you know. And by the way, that would require that notice. Then you file an answer, and if it would be dismissed, or they would bring you in front of them, then they have to prove by clear and convincing evidence that you know. I've never been there in front of them, but there's a procedure there. Clear and convincing evidence is the standard. If somebody was messing around and took me in front of the disciplinary board, I think I would want to have an attorney. You know. Okay, those of you who are coming back, we'll spend some more time on other things. Who's not coming back? Okay, please leave me your card, those of you who are not coming back, and make sure you sign that thing, the email thing, because I really appreciate how kind you were and whatnot. I know it's boring and dry, and it's this time, Christmas time, but I probably will never be back in Lansdale. Is that what this place is called, Lansdale? But my future son-in-law lives in Allentown. His parents are from Allentown. They taught school here. Is Allentown nearby?
Yep.
Okay.
20 miles.
Please leave your business card, okay? Because and by the way, I will send you this software. If you can't download it from the website for free, you call me and I'll show you how to download it, okay? Siobhan, welcome to my law office. And you want to be divorced, is that correct?
It is.
Okay. And I'm assuming you listened to me and now you need to know how much it costs, right?
Exactly right.
Okay. So in front of you is a list of things that we would be doing, okay? And the first thing I want to draw your attention to is that's us up here. We are the offeror,
Okay.
and you are the offeree,
Okay.
okay? And that is that your correct name, obviously?
It is.
Okay. And down here is the start date. And when do you want us to start on this project?
Immediately.
Immediately?
Yes.
Okay. All right, very good. So we will have you put today's date in there.
Okay.
Now, do you have any children?
Yes,
Okay, so this is going to involve a custody issue too.
it will.
Okay, and are you separated from this gentleman?
Yes.
Okay. And you want to actually be divorced?
Yes, indeed.
Okay. Now you understand that to be divorced, we have to file a divorce complaint.
Yes.
All right. So the first thing we're going to have to do under what we call pleading, underneath that is called the tasks, okay?
Yes.
So the task, you can just write the word complaint under there. And in this box, we're estimating that would take 3.25 hours, okay? Okay, now down here, we would need to file and serve that complaint. So where it says serve and where it says file, put in 1.5 there too, okay?
For each one?
Yep. All right. Now, the serving and the filing is not just the act of serving and filing, but that's verifying it with the court. And we need to file a custody complaint. That's a separate document, okay?
Okay.
So on line B, you can put custody and put 2.5. Alrighty? And now, we don't know whether your husband's going to fight this or not, right?
Oh, he's gonna fight it.
Okay, but for right now, we don't know for sure in my hypothetical. So we're not going to put anything in the hearing section, okay?
Okay.
Because that's in the future. I'm just letting you know that if he does, we would have to have some kind of a quotation on the hearings, but we're not budgeting any time for that.
All right.
I think you want us to keep the price as low as possible, right?
Yes, I do.
But by keeping the price low, I keep things off of the list. By doing that, though, I might have to have those on the list next time.
Okay,
But you pre-approve that.
okay.
Okay. So down below here, we show miscellaneous, and we're going to just put 2 billable hours in there. And for correspondence, we're going to put 2 in there. Okay? Now, there's over on this side is a out-of-pocket expense of a filing fee, and we're going to put $100 there.
That's how much it costs to file a complaint?
Yeah, that's what the county of
Montgomery.
Montgomery is charging right now. It's a
Okay.
special at Christmas time. Okay. So we show 12.75 hours, okay?
Okay,
And this is our hourly rate down here,
praise Jesus.
which is $2.75 per hour. And we believe we should praise too, but not because of our hourly rate.
Gotcha.
Okay, so 275 times 12.75. And that adds out to be $3,506.25 and $100 for the county of, what county is that again? Montgomery?
Yes.
So we have $3,606.25. Okay? Now, this is an estimate,
Okay.
but based upon our understanding of what the times and tasks would be necessary, this is what we are suggesting would need to be done on phase 1. Let's put this up here, phase 1 of this task list, okay?
Okay,
Having said that, you now are free to hire us or not hire us, and the consultation is free.
okay,
Now, we have 2 types of payment plan. You can pay 1/2 of that down and make payments on the second half, or you can pay it all up front, and we'll give you a 20% discount for doing that. We're not going to do the math right now. But your options right now, at this point in time, are number 1, to remember that this is for these tasks only. However, this law office won't bill you anything ever again unless you pre-approve it with another conference for another phase.
okay,
So this gives you an opportunity to see how the file is going and see how we're doing, quite frankly. You're not stuck with us. So your first option is to say no, the consultation's free. Your second option is to pay 1/2 down and make payments. Your third option is to pay all of it down and get a discount. And your fourth option is to think about it and shop around. Do you understand that?
I do.
So you may not like the price, but do you understand how we arrived at it, and it's somewhat fair, at least that you know what you're getting into?
Absolutely.
Okay, great. Okay, what's your name again?
Siobhan.
Okay, Siobhan, my name is Billy Bob Aluminum Siding Company, okay? And I understand you want aluminum siding,
I do.
okay? Well, sure, I'll get some money off of you and I'll show up and we'll get started. Do you want to hire me?
No,
Why?
what are you gonna do? How much does it cost? How much money do I
Okay.
have to have down? What color are we gonna pick? What materials are you gonna use?
Okay, good questions. Okay, so up here is Billy Bob Siding Company,
Yes.
okay? And this is who you are. Is that your correct spelling of your name?
It is.
Okay. And we have these tasks, and this is a phase. First of all, when do you want the siding job to start?
Well, it depends. Are you doing discounts for the winter?
Well, no, we don't have any discount program for the winter.
Okay. Well, I have a leak, so I think I need to start as soon as possible.
Okay, so put in Monday's date,
Monday, next Monday?
whatever, yep.
Okay.
So that's our start date. We've agreed on that. Now, we are going to need to tear the roof off. So you want to put under A, tear roof off?
Why do you need to tear the roof off if you're doing siding?
Okay, that's in my hypothetical. So we're doing siding. Your roof's fine, right?
Right.
Okay, so we need to tear the old siding off.
Gotcha.
So tear off. Just put tear off. And you could put 48 for the hours to do that. 2 days of work.
Oh,
Okay?
48.
This is our estimate.
okay.
Okay? Then new siding, and you can put 48 for that. So now that would be 2 full days, but we're obviously not billing that. So I'm sorry, we're going to do 16 and 16 instead of 48.
Okay.
So we estimate that it'll take 16 hours to do that. Okay? Now, we suggest that that'll get us where we need to go. Now, over here are the out-of-pocket expenses. We need to buy 10 crates of siding. And that would be $2,000. So we bill at $30 per hour. Does that sound fair?
I guess.
Okay, so for right now, we take 30 times 32, right?
Right.
And that is $960. And we know that the new siding costs $2,000.
Yes.
So if we add that, parts and labor is $2,960.
Okay.
Now, again, you are free to accept this contract with us or get bids or work out some kind of payment arrangements, but this shows who you are, who we are, the start date, the hours, and the out-of-pocket expenses. Do you think that has accurately described something so you can at least compare it to somebody else's price?
Yes.
Okay. So, do you have any questions on that other than you shopping around?
No, not at this time.
Very good. Thank you.
Sure.
Okay, now we've already gone through the attorney-client thing, but this translates into the real world too. All of us as attorneys find ourselves defending somebody who's being sued by a contractor or defending some contractor who's being sued by the customer. And I'm suggesting to you that a lot of those suits would not exist if there were some key features that took place. One, that there would be a writing. Two, the persons identified as the contracting parties be identified. Three, the tasks that they agree need to be done and their hourly rate. Four, the amount of out-of-pocket expenses for materials. Five, the start date. And if those things were given some time and consideration, both the consumer and the provider could probably eliminate a lot of controversy. And even if they can't eliminate a controversy, they have something objective in which the controversy could be resolved rather quickly.